Head to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Baker and friends, it's second to none.
Hey everyone, and welcome back to hopefully closing arguments in the Natalie Cochran case, because this case, it's getting a little long in el tuzo, as they say in Mexico. And as the premier grifter on the YouTubes, Court TV has this little who is your favorite true crime creator? You can tag them below. Loyally, best unbiased live coverage on YouTube. Grizzly True Crime. Loyally, Grizzly True Crime. Crime Talk, Lawyer You Know. It's Know Your Lawyer. If any of you might have that failed notion that I have anything to do in a setup with people that cool, please, on the Discord, in the general chat, Marissa have put up the link, and I wouldn't mind having just one vote. Just for the grift. And you can also, if you want to play bingo, bingo, bingo. Why is my camera acting up? There's a link in top of Kitty Chat where you can get a bingo card. It has to be an X or a full plate, and only words mentioned during closing arguments will be counted for the bingo, bingo, bingo. If you get a bingo, you say bingo in chat and the little number you have. There should be 100 bingo plates. And if you just put your number in, then they can check if you were the one. Jemima, if you will allow her to get your address, we'll send you some. Why is my camera? I don't have autofocus on. Why does it keep doing that? If you want to win some stickers, I think she promised. You can send her your address and she'll ship you some stickers for being the Bingster of the Cochran case. Oh, thank you so much, Sue. Oh, and the free space is the magic 8-ball. I'm Lord Super Jason, not True Crime. Well, I don't know what you call what I'm doing. Some would call it late in French. Brendan, you don't have 03 again. Thank you so much, Farm Girl Mom. You want candy? Well, you can't have candy. Candy is only for Fridays when we watch the cartoons. You know it, and you every time we go out shopping, can I have a Yankee bar? No, Brandon. We've been talking about this. You have to cut down a little bit on the sugar because you become a little too riled up. So no candy, sir. Yeah, Lawyer Lee was just reading the victim impact statements from the financial case. They really didn't like her. Let's try and no autofocus. My camera is stupid. Have I got time to make tea before court come back? They'll be 15 minutes late. Then they'll argue, and we'll start somewhere around midnight. Yeah, if you go on my YouTube wall, I also shared the link there. You can nominate favorite YouTubers. What is an 8-ball? It's a little 8-ball like, from pool. In America, they have them where there's a little window on the back, and you'll shake it and you'll say, will Brandon behave? And then you'll shake it and it'll say, not likely. You can use it to, it's kind of like flipping a coin. You say, should I go on a diet? And it says yes, and you'll shake it again and it says no. And you say, oh, I agree with you. Well, I thought I'm honoring Victor by reminding you of how Poland used to be. Hey, Carly Kramer. Yeah, you can grow your tea before it's coming back. Racket has a very different answer to that question. Oh, I'm like all the girls on Instagram. You're so sweet, Crispy. You make all your huge decisions with your Magic 8-ball. My sister used to have one. I think she bought one when she was in, or maybe it was, no, I think it was my sister who bought it when she was in the States. But it's probably gone the way of the Dodo. Hey, Dodo. So, yeah, it's fun. You can shake it up. I think you can, isn't there a Magic 8-ball online? I think there is. Yeah, there it is. Will I win favorite creator? Ask. It'll never happen. This Magic 8-ball is, Jamie, did you invent this? Well, hasta la taco then. See you later. I was having such a good day, and now it's back to this. I could just stream with Jamie. It'll be the same. Just won't give you the link. Oh. I can do that. If I was gunning for mod of the year, I would share links like that. But maybe just let Valhalla win it again. Yes, thank you, Jemima, for doing the bingo. Go, go, go. Shower, shaved, hair wash. Now to wait an hour so I can blow out my hair, and I should be ready to leave by 2:30. Well, court will probably not be started by 2:30. The link for where to vote. But I did it. Don't worry. Yeah, the reason why we picked Magic 8 Ball is because the judge said he used his Magic 8 Ball. So none of the lawyers will say that word. So that's the free word. I think what was the free word in the Sarah Boone one? I can't remember. But it's just a little something to keep you occupied while hopefully they will do their closing arguments just as fast as they did their opening statements, because that was okay. But I have my suspicions it can go quite long. Oh, he said his extent of technology was his Magic 8 Ball. Thank you, Gina. Was it Alkylex? Yeah, it was Alkylex. Alkylex makes a man think of smacks. Sarah straddling the bush made me wanna smoke some kush. Come on, skinny Alkylex. Sorry. Magic 8 Ball never tells the truth. I hope not, because it said that I will never be a favorite creator. So a girl can dream. But I don't know. Oh, I forgot to put my watch for. Yeah, we're late. 3 minutes. Couldn't they come back 5 minutes early? Weren't they supposed to be back early and talk about oh, maybe. What did I do to this? Sorry, it just. No, that's not what I want to do. Hey, have you tried this before? Yeah, I'm actually a creator. Are you sure? Not that sure. Is it live? Yes, it's live. They were supposed to be back 10 minutes before to hash out the last problems. Didn't happen. Can't he like spam the post with comments to help win? Well, he only helps himself. Ba, 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 ba. Now it's stuck in my head for days. I was out shopping yesterday and standing in line. Someone started whistling the. I don't know what the tune is, from Mulan. Ba, 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 ba. A man like me, I think it's called in English, or All I Need Is Men, or something like that. You know, the training montage song, and it's just got stuck in my head. But I'm also a guy who uses Disney music when I'm lifting heavy because it works. Make a Man Out of You. Yeah, it's a good song. Any news on the Sandra Birdsmore trial? No, absolutely nothing, which is kind of weird because there are two other officers who, in my opinion, should be interesting. There are local cases, state cases that should have been brought, and nothing. I saw Missy was doing a show the other day, an update on it, and it's dead. Nothing happens in that case. At what point can Massachusetts live with this anymore? The Karen Reed case, Delgado Garcia, Sandra Birdsmore. When can't you live with this anymore in Massachusetts? When, even though I know the governor is busy with a lot of other stuff, at what point does it reach her table? Fox is now going to do a video on the Karen Reed case. Some say it's good, some say it's the worst ever, but it'll bring national attention to the Karen Reed case, a case that already have, I would say, hundreds of thousands of views when it's live. And the politicians will just do didn't happen. Let's get down to business. Well, I can't get more down than I already am. Court is late as ever. No, she's not. She was just a placeholder on it. It's been moved to another guy. Stephen talked about it earlier. So it's not going to be Bev, because I was looking at it, and if it was televised, just to see how she is in other cases, and if it had been televised, I would have looked at it, but she's been moved off that case. They're late. They've been late every day. It is very disgusting, yes. I don't know who Peyton Paris is, but I most Disney songs I listen to in Danish. Oh, Plant Fan is having a great day. They are normally 15 to 20 minutes late after every break. We're not just, let's take a 10-minute break. It's a 30-minute break. Oh, someone is in court and someone has had a bad day. Not so much Swacia. Oh, your Swacia is up there. So you're mad and Swaciaing. Well, I would like to see her, because we went back and watched Judge Mummy from the Brooks trial. She had a Vicine poisoning case, and I wanted to go back and see if she was better when it wasn't Brooks. And I know some people love her because she's so thorough. She can't not talk for 20 minutes at a time. Every objection takes 45 minutes to get through. I think we dropped it after 2 days because it was just so slow. Judge Darrow, she is annoying. She is slow. And I know, well, she's saving it for appeal. You don't have to, every time you make a ruling, give us every case law in the history of the state of Wisconsin. Just say, sustained, I object. Then you'll write why later and give it to the lawyers. Oh, I just want to put it on the record. Get out of here. Jemima has a good day. You got this, Waisha. Hey, 80s. You don't got this, Waisha. People are really mean today. That's how I feel about the Rittenhouse judge. After watching the Zachariah Anderson case, that guy should have retired. He was already showing signs of not being all the way there during the Rittenhouse trial. Zachariah Anderson really Yeah, that was a bad case. You can't write why later. Well, you can just say sustained then. You don't have to, or you can make a short ruling, say, I'll allow it. You don't have to say, well, according to Massachusetts 204 Mass v. Jemima case law, interesting, from 2017. This was over a stolen carton of cigarettes, Newports, and 2 dozens of eggs. And in that case, they provided a receipt that showed that he allegedly purchased the 2 cartons of cigarettes, but it wasn't Newports. That was Marlboro. So that's why I reject this objection. Sorry, what? Yeah, it was really kindergarten. Rian, we won't be moving anywhere. Bad days. No, when he was caught napping, and every story he had started with, back in junior high, I had this guy, Jesus, 2 classes under me. He grew up to be a famous carpenter or something. But I remember, then you know he's too old. It's really low numbers today. Really, really low numbers. Anyone else remember when you could send in parts of the cigarette boxes to get things from Marlboro? Don't think we ever could do that in Denmark. Money cheap, only 40%. But very baked. Very, very baked. How old is too old? It's highly dependent on your mental state. I used to live in an apartment complex. The lady living above me, I think she must be in close to 80, maybe early 80s. She goes to the gym almost every day, physical active, travels, talks to a lot of people. She's fine. Then I have another person who used to be my gym teacher in school, and he's probably not, he might be 70, and you can't have a conversation with him. It's just clouded. So it's highly dependent on your mental state. And Schroeder was he couldn't keep up with the trial. He was watching Recovery Addict while trial was going on. That's just not good. Are me and Jamie a couple or just friends? Jamie is the owner of JNN, Jamie News Network, where I am lucky enough that she will let me stream on that, and I only have to pay her 110% of my income every month on YouTube. So she's more like my boss. She's also my HR representative, my union rep. So she has a lot of roles, and all of them is she gets to yell at me. Yeah, but she was a placeholder. Her name has been changed. She also have an evidential hearing with the Karen Reed case on Friday. So that's why we were talking behind the scenes as what's going on. Is she going to do a bench trial while she's having another hearing going on? But her name was just slotted in, and so it's a male judge who's going to take it. Schroeder had some kind of brain problem, and his wife was really sick, so there was a lot of things. Yeah, Recovery Addict is getting into all the trials right now. At what point can't he be a law tuber anymore, but he's a professional court interrupter? Thank you. Never listen to what I'm saying, but no, Jamie lives in Manitoba. I don't know. In the US, I live in Denmark. I don't do long distance, and she don't like me. So that's not going to happen. But she's flying over here to meet me and tell me how much she disliked me in person. That's going to be fine. Got to get her drunk, and she can sit and tell me how stupid I am. I have a 93-year-old aunt who looks about 60, if that. I hate her. Yeah. And some people, they lose it when they're 40. It's so different. Objection, unresponsive. Yeah. She is the fashionista of the channel. Many Little said she has been listening, so that is odd. Listening to... I can bring up what Scott McGinnis... No, Stephen shared today. If you are on the Discord, it's in... Take a look. It's going to be... She was just a session judge, and Judge Larry Tipton is the event judge, is what he's saying. So, do this and imbigonate. No, take this off screen. Get it on the other. Oh, just when I'm about to do it.
All right. Have you received a copy of the court's charge? Here it is.
You can see up here. Larry Tipton, Esquire.
We have one, but I don't know that it's been approved by the other side.
They had it.
Where is HR? I want my member chat. I want a bingo card. I want a magic 8-ball. I want a golden goose, not a hot dog, not a hamburger. Brandon, you have to file a request with HR. Send it to Jamie's home address, marked complaint. Then you'll have to wait between 20 and 40 business days for a response. She'll probably write rejected. I'll just save you the postage, because I have done this every week since I started streaming with Jamie, and I just get a boilerplate rejected. But everything must go through HR, which is Jamie, and you can reach her at the PO Box. She always said I have to mark it PO Box FU. I thought it was a number, but apparently she has a special address.
It's pretty simple and straightforward. Thank you for the list, Angie. Thank you so much.
Don't steal a pig. Pretty good sound advice. Yeah, and I think they have already all the way down to involuntary manslaughter. Then they should just toss the case. If they don't believe enough in themselves that they will have to go down to involuntary, toss the case.
Okay. She said she took it right off the label.
I've never seen Caddyshack.
Okay.
I know the golden ticket is
All right.
Willy Wonka.
Can the defense approve the court's charge?
Final stages.
Okay.
Oh, yeah.
Exactly. And especially if you're going for murder one or none. That should be it. Yeah, but they shouldn't be allowed to, especially on you can say, okay, is this a theft or maybe someone is fencing stolen goods? That could be okay.
That's the most recent one. I think
But if you're going for murder one, you don't get to go for involuntary. I want to get confused. The pig squealed on me. I love that case where a man
All
was
right, let me ask
charged,
counsel,
with-
how much time do you require or
pig.
request for argument?
30 minutes. 30
Your Honor,
minutes.
we'll defer to the defense.
30 minutes.
I don't know. The state has the burden of proof. Maybe the state can.
20 minutes?
Half an hour?
Half an hour?
20 minutes. Come on.
Hey, want to do that 45
Okay, 45 minutes.
45 minutes?
Yes, Your Honor.
Okay, will you be doing the closing, Ms. Akert?
Yes, I will, Your Honor.
Okay, how do you want to divide your time?
No, and that's the big problem is the judge just roll with it. And I hate it. It's because it's an old movie. It's before my time. I didn't see The Big Lebowski until last year.
35 for closing and 10 for rebuttal, Your Honor.
Do you want a discreet 1-minute warning
I would appreciate that, Your Honor. Thank you.
on both ends?
Please.
That would give the defense the full 45 minutes if you wish to take it. Do you wish a 1-minute warning, 2 minutes, or what? This,
2-minute warning is fine.
pardon?
2-minute warning is
2
fine. Your
minutes.
Honor.
All right, here's the final question I have for you. It's going to take me a little while to read these instructions because it's 18 pages. Do you want to take a brief recess between the court charge and the closing arguments, or do you wish to go on through?
Walk
It's up
on
to
through
you.
to the other side. Walk
Well,
on
the
through to the
instructions,
other
I
side.
thought we were placing the involuntary manslaughter before the instructions dealing with malice.
I thought that's what we did.
Yeah, I thought so too, but it's not the case.
I think the penguin is closing, yes. Imagine 35 minutes and Mr. Slow going. Well,
Opposed.
Okay.
members, I'll have
It would
to.
just be a matter of cutting and pasting page 10.
2
where it
minutes.
Starts with the definition and moving it before the discussion of malice on page 9.
Okay. I'm going to ask you two to
18 minutes isn't that bad. I read Baldoni and Blake Lively, 3 of the different lawsuits. I think the longest one I read was 182 pages. No, 156 pages. And now there's a 4th lawsuit. I'm not going to read that because I think it's close to 200 pages. So I'll probably just do a quick update video on that because that case is going to go crazy with the PR on both sides.
go with Ms. Brown Bailey and assist her so that
No.
set it
You have a
forth
great meeting and
appropriately.
go get dinner and you'll be back in time. Well, the life of a YouTuber. Well, it's because I'm Danish. We do things on time. We don't dilly-dally around and do stuff. Stuff like this should just be in order. You don't have to dilly-dally as much as they do. It's a waste of everyone's time. And most of all, it's a waste of your money because you're the taxpayer. We don't have closing arguments where he has to read the instructions. We don't need to be told what's reasonable doubt. We are told that the first time we go to court. We don't have to sit through 18 pages and did they prove it? Did they prove it enough? Did they and do you and maybe you wanted donuts instead of biscuits, but it's okay. We don't do that. Closing arguments will be, I believe I have proven it based on this, and this. The defense will be, remember, reasonable doubt must be granted to my client. I believe that they didn't prove it because this, and this. If you feel they did, so of course I want them set free. If you feel that they might have done it, they should probably get about this amount of time. And prosecution have also said how much time they believe they should have based on. Normally, we get 2 or 3 case laws where they'll just read that in the law books. It's this case where similar circumstances gave someone 3 months, and then they have this one where similar circumstances gave 2.5 months, so we're going for 3 months. Defense will have found someone that said similar circumstances gave 1 month, so we believe you should be there, and then we'll say anything that defendant wants to say. You always have the last word, and they'll say no, and we'll say okay, we'll retire, and we'll go back. First thing the judge says, have they proven guilt as charged? And we'll have the charging document, and we'll go over it and say, did Jamie on the 25th of the 11th say, I'm going to unalive Baker when I get to Denmark? Yes, that has been proven, as she said it multiple places. Good. What do we find? So we find her guilty. How much should that cost? Well, she has a history of trying to unalive people, so she probably should have to pay this time. And then we'll sit there and say, well, one side said 1 month, one side said 3 months. This is pretty bad, so we're probably closer to 3 months. Can we agree on 2.5, 3 months? And someone will say, well, Jamie's such a nice person. I really liked her eyelashes. And they'll say, yeah, that's right. Let's give her 2 months. And then we'll go back in and say, hey, Jamie, you're going to go to the slammer for 2 months. You have to pay the court cost, or you don't have to pay the court cost. See you later, alligator. That's how you do it. Boom. No, he did. What he said was he did the cross-examination. He didn't say closing. He said cross-examination.
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break, and both sides take a pregnant pause and think about the jury.
And thank you, Krista, for 3 corner kisses. Hey, Baker, thank you for creating a new Lego edition. I'm getting the money tree, bamboo tree, and the llama. You should have an Amazon link to benefit from the addiction you created. Best grifter ever. Sending you lots of love. Thank you so much, Krista. I don't know what an Amazon link is. We don't have Amazon in Denmark, so I never... But if it's something I can put up there so you can see all the weird stuff I have bought, so because people are asking what kind of mixer am I using and stuff like that, I could do that. This is the aforementioned money tree. Valhalla won this on my last giveaway. It's a new series they just released for the Chinese New Year. There's a money tree, there's a calendar, there was a bamboo. So I should be paid by Lego. I heard your real laugh again when Penguin Lawyer made a funny. Will you add that to your memes? Oh, the small videos I play. I actually put up a short because someone said, "Are you gonna share it?" So I put it up as a short, and I don't know if I laughed in that one, but I did cut it out when he said, "Hi, on a hawk." I love that guy. Such a weird way. High on a hawk. Why would you live on top of a hawk? The world is a disc on top of a turtle. I can understand that, but why a pig? Pig is in mud.
Honey, I'm taking you to Paris and I'm gonna get you a Louis Vuitton bag for God only knows how many thousands of dollars because we have somebody else's money to live high on a hog, right? He's not
To live high on a hawk. I love this guy.
for God only knows how many thousands of dollars because we have somebody else's money to live high on a hog, right? These documents don't deal with this.
Who doesn't like Jamie's eyelashes? I said she gets 0 time and the court owes her $1 million. Could be. We don't know what they were fed today. I hope it was good. Amazon wishlist. Again, I've never purchased anything on Amazon. The only thing I have is Amazon Prime because I can watch that on my television. They're talking about maybe making an Amazon Nordic or something, but the only thing I can buy from, well, I can buy from everywhere, but the closest is Amazon Germany. He is a hoot. Hi, on the hawk. I've reached out to a few people and they don't respond to me. Yeah. No, that was just his cross-examination earlier. My client is a bad girl. Yeah, I should have cut that out as well. Yeah, I when people said that, oh, you should clip that, I thought, well, I never put out any shorts, so maybe I should do that. Apparently, YouTube likes it when you put out shorts. Yeah, just remember to use your Eastern European Polish accent. I made pizza because of yesterday's pizza talk. It's no calories on my shorts. How can you make pizza that's no calories? So you're eating air. Because air, I think, is the only thing that has 0 calories. High on the hawk only gets better if you frolic on the beach too. Facts. Yes, he did that Friday, I believe. He won't get his sentencing till April, but he has pled guilty, which I think most of us believed he would do. I know a lot of people have been doing a lot of videos on it because it gave them a lot of views. Because
charge, I see that we have switched the elements for involuntary manslaughter with the definitions of malice. Is that correct, counsel?
Correct.
Yes, Your Honor.
And we haven't changed the wording of anything. We've simply
I'm sorry, I do it almost every day. I do popular ones, I do unpopular ones. It's just whatever fits into my schedule. So you're always welcome here.
moved those segments around as indicated.
It was a cut.
Yeah, but I just don't like kicking people when they're down. I know I'm covering trials. I'm kicking people all the time because I'm yelling at them. But when this broke almost a year ago, just before I went to Tennessee. I said, if he can straighten up, stay clean, he'll be back and bigger than all these people who made fun of him. And I've seen him on a few shows. He seems to have cleaned up. He's getting tested. If he's back, he needs to get the ring rust off because it's hard to get back into the game. But imagine him going in on the Karen Reed case. He would beat most of every other channel covering it. Americans love to kick your kings down, and you love to build them up afterwards. Just see how much it switched already when he did his show last week, where people were back and saying, well, we were a little harsh on you.
The pace. Yes, sir.
Yes, Your Honor.
All right. That's agreeable, certainly with the court. That's what we discussed. One more thing. Do either of you wish to have the podium set up in front of the jury box?
Yes, Your Honor.
All right. I'll ask
Yeah.
the bailiff to do that.
The lesser
please.
will always get them convicted.
And Your Honor, while we're doing that, after some reflection, I'm thinking
Oh, no,
I
I'm
might need a
just-
little more time.
I said sorry because I'm already streaming 40 to 50 hours a week. I can't fit more in.
For closing. If we could have an hour total, I won't need that long, but I think mine will probably run about 45 minutes on its own.
Nope. You said 45 minutes. You get 45 minutes in total. Tell her you better. You said 20 minutes to begin with. Don't start with this BS now.
All right. So you'd like to have an hour altogether.
Yes, Your Honor.
And how do you want to divide that?
45,
No, it's fine, Crispy. I was just saying because
45 and 15, Your Honor.
a lot of people have been arguing that. Oh, why don't you?
You still would like to have the
because I don't
1
like
minute
it.
warning?
Yes, please.
I don't think he's a shambles, and at least he's been.
And that would
He's testing
afford
clean every day.
to Mr. Victor
testing clean for a year.
a full 60 minutes. Is that agreeable?
Yes, sir.
With the 2 minute warning?
Yes, sir.
All right. Are we ready for the jury?
No, let's wait another 48 hours.
Bring in the jury, please.
And Your Honor, the state does think that it would be appropriate to take a break between the charge and beginning closings, given the length of the closings.
Okay. I think that's probably a good idea.
I really don't think she should have been given. She said 20 minutes to begin with. Well, if she's going for an hour, I think it's fair that they'll get a small break before the defense goes because you can't concentrate. Well, I don't know if they're going to split it, but she's going for 45 minutes, and then she's saving the 15 minutes to rebuttal closings.
Members of the jury, the next phase or stage of this case, as I touched on earlier, is the instruction of the law by the court. I can tell you that this is a very boring and tedious part of any trial. And perhaps some of you who have served as jurors before know that very fact. Sadly, you must pay strict attention to what I tell you. Your oath requires you to apply the law that I will state to you to the facts you determine from the evidence. So this is a very important stage or part of any trial. Members of the jury, you have now heard and seen all of the evidence in this case. You are the sole judges of that evidence and the facts that it establishes. It is your sworn duty to determine and base your verdict only upon that evidence. In doing so, do not be influenced by sympathy, anger, passion, prejudice, or public sentiment. It is now my duty to inform you about the law that applies to this case. You have no right or privilege to disregard these instructions or to form a different opinion about what the applicable law is or should be. All of these instructions are important. Do not pick out one part and ignore other parts. You are to draw no inference from the order or manner in which they are given, and they are to be considered by you in their entirety as a whole. The indictment in this case is merely an accusation, and it is not any evidence of guilt. The burden is on the state to prove the guilt of the defendant beyond a reasonable doubt. The defendant is not required to prove her innocence. Our law presumes a defendant to be innocent of crime. So the defendant, although accused, begins the trial with a clean slate with no evidence against her. And the law permits nothing but legal evidence to be considered in support of any accusation. So you see, the presumption of innocence alone is sufficient to acquit the defendant. You must determine the facts of this case from the evidence only, that is, from the testimony of witnesses and exhibits. Disregard completely testimony to which an objection was sustained or exhibits ordered stricken out of the record. Absolutely nothing that I have said or done during this trial is to be considered by you as evidence or as any indication of an opinion concerning the weight of the evidence, the credibility of the witnesses, or the guilt or innocence of this defendant. Nothing that I, as judge, said or did at any time during this trial is to be considered by you as evidence of any fact or as an indication of any opinion as to any fact or evidence, or as a measure of the credibility or truthfulness of any witness who testified, or as to the weight you should give to such testimony, or as to what your verdict should be in this case. For you are the sole judges of such matters, and I am only the judge as to the applicable law.
I think it's only before.
The evidence from which you are to determine and base your verdict
Early
consists
40s.
of the sworn testimony of all of the witnesses, regardless of which side called them as witnesses and whether their testimony occurred on direct or cross-examination. The exhibits that were received into evidence, regardless of who introduced them into evidence. Any facts which I have told you were agreed upon by stipulation or otherwise, and any fact which I took judicial notice of. However, if you do not agree with that fact, you are not bound to accept it. Members of the jury, there are two basic kinds of evidence, direct and circumstantial. Direct evidence is testimony as to what a witness saw, heard, or did. Circumstantial evidence is indirect evidence, that is, it is the evidence of a fact from which another fact, not directly testified about, can be inferred or found. Both of these kinds of evidence may be considered, and it is for you to determine and decide whether or not a fact has been proven by circumstantial evidence by considering all of the evidence in light of reason, common sense, and experience. There is no quantitative difference between direct and circumstantial evidence. The following elements are not evidence, ladies and gentlemen, and you are not to consider them as evidence for any purpose whatsoever. Anything that any of you have seen or heard outside of the courtroom or when court was not in session. Do not consider or be influenced by any testimony or evidence which has been excluded and not put into evidence, and do not consider or be influenced by any testimony, evidence, or any other fact or subject that I instructed you to disregard and not to consider as evidence. If during the trial I instructed you to consider certain testimony, evidence, or facts only for a particular or limited purpose, you are to continue to do so and must consider such matters only in that manner and for that limited purpose.
Yes, yes.
Do not be influenced by or draw any inference from any objections that were made by the lawyers during this trial.
Yes, please, if you want to play along with bingo, get your bingo cards by hitting the link in top of chat. You have to either make a cross, X on the plate, or fill out the plate. Jeepers, this is...
What they said to you in their opening statements, or what they will say to you in their final closing arguments, or at other times, were and are made to aid you in following, determining, and interpreting the evidence as it relates to the issues before you and their respective sides of this case. While you must carefully consider the testimony of each and every witness and not disregard or overlook any testimony, witness, or evidence, the jury is the final judge of the credibility of the witnesses and the weight of the evidence. The number of witnesses testifying on one side or the other of an issue is not the only test of weight and credibility. If you feel that the evidence justifies it, you may believe one witness over a number of witnesses testifying differently. The test is how truthful is the witness and how convincing is the testimony in light of all of the evidence and circumstances shown. As jurors, you are also entitled to draw reasonable inferences and make reasonable deductions from any of the testimony or other evidence as you come to believe are justified in the light of reason, common sense, and experience. If you come to believe that any witness did not tell the truth about any material fact after carefully weighing and considering such testimony, you may disregard it or any part of it, or give to it or to any part of it such weight and credit you determine it deserves. In weighing and crediting the testimony of any witness, you may consider the good or bad.
Holly Mac, it's because Nick Ricader was a very, very big law tuber. He was probably the biggest law tuber there was. He kind of started most of the law tubing, made it very popular. Then he had an unfortunate downfall because of some Colombian-based problems, and he had some very interesting streams in the end. Let's just say that. He also was one of the ones who invented the pay me to drink that so many people use now. And sometimes it might have gotten a little too far. And let's just say, if you hung around for his night streams, you would learn things that sweet summer children shouldn't know about. But a great law tuber.
Bad memory of the witness, the interest of the witness in the outcome of the trial, the relationship of the witness to the parties
An X and a full card.
involved in the case or to other witnesses, the attitude and manner of testifying of the witness, the opportunity and means or the lack of opportunity and means of the witness to learn and to have knowledge of the matters about which he or she have testified, the reasonableness or unreasonableness of the testimony of the witness, the intelligence of the witness, the appearance of bias or hostility or friendliness or unfriendliness of the witness to the parties involved in the case or to any other witness, and any contradictory acts or statements of any witness that you determine were done or made that served to contradict the testimony of such witness in court. From all such factors and considerations that appear from all the evidence and circumstances shown in the case, you are to evaluate the testimony of all of the witnesses and the weight to be given to their testimony and determine the credit you believe it is entitled to receive. In this case, you have heard testimony by witnesses who are presented as experts, who by knowledge, skill, experience, training, or education had acquired scientific, technical, or specialized knowledge in the field or area about which he or she has testified. As an expert, he or she is therefore entitled to express an opinion.
How many people, one in chat, if your mind is on Squirrel Patrol right now? I'm having the Homer Simpson moment in my head.
Upon matters within his or her field or specialized knowledge and to state the reasons for an opinion. Expert testimony is to be considered and evaluated as you would the testimony of any other witness. You may accept or reject it in whole or in part, or give to it or any part of it such credit and weight you come to believe it deserves. In evaluating expert testimony, you should consider the knowledge, skill, experience, training, and education of the expert, and the basis and reasons given for his or her opinion in light of all other testimony and evidence in this case. The court instructs the jury that evidence of other crimes, wrongs, or of acts by the accused is not to be considered to prove her character in order to show that she acted in conformity therewith. However, the jury may consider such evidence for other purposes, such as proof of motive, opportunity, intent, preparation, plan, identity, and absence of mistake or accident as to the crimes charged. This court has taken judicial notice of court documents generated by the United States District Court, Southern District of West Virginia. That is, the court has taken as fact that the litigation in the United States District Court, Southern District of West Virginia, occurred based upon the determination of sources whose accuracy cannot reasonably be questioned. You are instructed, however, that you may or may not accept that fact as conclusive. The offense charged in the indictment in this case is murder of the first degree. You may return one of two verdicts pertaining to murder of the first degree under the indictment. They are 1, guilty, and 2, not guilty. Murder of the first degree is any felonious, willful, malicious, deliberate, premeditated killing of another person. Murder of the first degree consists of an intentional, deliberate, and premeditated killing, which means that the killing is done after a period of time for prior consideration. The duration of that period cannot be arbitrarily fixed. The time in which to form a deliberate and premeditated design varies as the minds and temperaments of people differ and according to the circumstances in which they may be placed. Any interval of time between the forming of the intent to kill and the execution of that intent, which is of sufficient duration for the defendant to be fully conscious of what she intended, is sufficient to prove a deliberate and premeditated killing and to support a conviction for first-degree murder. Before the defendant can be convicted of murder of the first degree, the state of West Virginia must prove to the satisfaction of the jury beyond a reasonable doubt that 1, the defendant Natalie Page Cochran, 2, in Raleigh County, West Virginia, 3, on or about the 11th day of February 2019, 4, feloniously, willfully, maliciously, deliberately, and unlawfully and premeditatedly slayed, killed, and murdered 5, Michael Cochran. After impartially considering, weighing, and comparing all of the evidence, if the jury and each member of the jury is convinced beyond a reasonable doubt of the truth of the charge as to each of these elements of murder of the first degree, you may find Natalie Page Cochran guilty of murder of the first degree as charged in the indictment. If the jury and each member of the jury has a reasonable doubt of the truth of the charge as to any one or more of the elements of murder of the first degree, you shall find the defendant Natalie Page Cochran not guilty. Involuntary manslaughter is committed when a person caused the unintentional death of another person. This court instructs the jury that the absence of an intention to kill or to commit any unlawful act which might reasonably produce death or great bodily harm is the main element of involuntary manslaughter. A person is guilty of involuntary manslaughter when a person commits an act in a reckless or grossly negligent manner and unintentionally causes the death of another person. Therefore, in order to find the defendant, Natalie Page Cochran, guilty of the offense of involuntary manslaughter, the state of West Virginia must overcome the presumption of innocence and prove beyond a reasonable doubt each and every one of the following elements. 1, that the defendant, Natalie Page Cochran, 2, on the 11th day of February 2019, 3, in Raleigh County, West Virginia, 4, unintentionally, 5, caused the death, 6, of Michael Cochran, and 7, against the peace and dignity of the state. If each and every juror is not...
This is absolutely BS. If you want to swing for the first, you stick with the first. I hate this.
Convinced beyond a reasonable doubt that the state of West Virginia proved beyond a reasonable doubt each and every element of the offense of involuntary manslaughter, the jury must find the defendant, Natalie Page Cochran, not guilty. Malice is a subjective state of mind of the defendant. It may be proven by evidence of circumstances surrounding the crime, such as words or conduct of the defendant before, during, and after the event, or evidence of ill will or a source of antagonism between the defendant and the deceased. Also, malice may be inferred from a deliberate cruel act, indicating a heart disregarding social duty and fatally bent on mischief. Malice and intent also may be inferred from the defendant's intentional use of a deadly weapon under circumstances which the jury does not believe gave her legal excuse, justification, or provocation for such conduct. Malice may be expressed to include not only anger, hatred, and revenge, but other unjustifiable motives. It may be inferred by you from all of the evidence in this case if you find such inferences reasonable from the facts and circumstances in this case, which have been proven to your satisfaction beyond a reasonable doubt. Malice may be also inferred from any deliberate and cruel act done by the defendant without any reasonable provocation or excuse, however sudden. Malice is not confined to ill will toward any one particular person, but malice is every evil design in general. It is not necessary that malice must have existed for any particular length of time, and it may first exist at the time of the killing or at any previous time. As a defendant is presumed innocent of the charges brought against her, she does not have to prove herself innocent and is not required to call any witness or produce any evidence. She is also not required to take the witness stand and testify, for she has a constitutional right not to do so. The fact
Yeah, and I think that's BS because they wanted her for murder one. You prove murder one. You don't get well. She should probably have taken him to the hospital, and she must be guilty of something because she's charged. We see that in every case. As I don't know if there is a defense lawyer union, but I would argue that all of these lesser included should be eliminated. The state should have, if they want to have a lesser included, they should throw away the possibility for murder one.
that the defendant did not testify is not any evidence against her, and you shall not consider that she did not testify or draw any inference from that fact as to the guilt or innocence of the charges brought against her. You must entirely disregard it and not discuss it. The court reminds the jury that throughout this trial, the state maintains the burden of proving the defendant's guilt of the crimes charged beyond a reasonable doubt.
Involuntary manslaughter in West Virginia Code is a misdemeanor, and any person convicted thereof shall be confined in jail not to extend 1 year. So we're going from life in prison to 1 year in the charges that the state wanted. You shouldn't be allowed to have this big of a gap. This is absolutely ridiculous.
From time to time during this trial, it was necessary for me to talk with the attorneys out of the hearing of the jury, whether by having a conference at the bench when the jury is present in the courtroom or by calling a recess. Most of these conferences
because they
involve
claim she's
determinations
innocent.
as to whether evidence is admissible.
They can't say, hey, can we just get some few lesser included in there? They claim she's innocent and she should be set free. So I don't think
under
they're
the
doing
rules
it.
of evidence. It is appropriate to take these matters up outside the presence of the jury.
I don't know if they did it, but still, I can't see why they should. I just think it's BS. And why would you ask for a lesser included when it's so far from what she's charged with? I wouldn't go and say, well, if we can't get murder one, let us just put in lesser an involuntary manslaughter. Well, it gives the jury an option, but if they're going to go for involuntary manslaughter, they would never have gone for first degree anyway.
If I concluded that a more prolonged discussion was necessary, I may have excused you from the courtroom. You've heard evidence concerning alleged conduct or other acts of the defendant, Natalie Cochran, which are not charged in the indictment. You are instructed that such evidence is not admitted as proof of the defendant's guilt on the present charges. This evidence is admitted for a limited purpose only, and it may be considered by you in deciding whether a given issue or element relevant to the present charge has been proven. Accordingly, this evidence may be considered by you only for the limited purpose for which it has been admitted. In this instance, the evidence of the defendant, Natalie Cochran, alleged criminal acts of the, quote, Ponzi scheme, unquote, may be considered only for the purpose of determining whether the state of West Virginia has established the motive to perpetuate the first-degree murder. You are instructed that upon the trial of this case, if reasonable doubt of any fact necessary to establish the guilt of Natalie Page Cochran, the defendant, as charged in the indictment, be raised by the evidence or lack of evidence, such doubt is decisive,
No, I said no more than a year.
and the jury must acquit the defendant, Natalie Page Cochran. You do not have to believe that the
But
defendant,
they
Natalie
could give
Page
her a
Cochran, is
fine of
innocent of
fine
the
of
charges
$5,000
against her
for
in order to find a
involuntary manslaughter
verdict of
instead.
not guilty. Your verdict of not guilty only means that the state of West Virginia has failed to prove to you the guilt of the defendant, Natalie Page Cochran, beyond a reasonable doubt. The jury is instructed that the mere presence of the defendant at the place of the alleged crime or crimes does not in and of itself indicate participation of the defendant in the criminal act or acts. The defendant's mere presence at the scene of a crime or mere knowledge that a crime is being committed is not sufficient to establish that the defendant committed the crime charged in the indictment unless you find that the defendant was a participant and not merely a knowing spectator. The state of West Virginia must demonstrate to the jury beyond a reasonable doubt a nexus between the defendant's presence at the scene of the crime or crimes at the time or times of the alleged crime or crimes and her participation in the criminal act or acts. In relation to any and all charges contained in the indictment in this case, if each and every member of the jury is not convinced beyond a reasonable doubt as to each and every element of the offenses charged, the jury must find the defendant not guilty. If the jury has a reasonable doubt as to the grade of the offense of which the defendant, Natalie Page Cochran, may be guilty, the jury shall resolve that doubt in favor of the defendant, Natalie Page Cochran, and find her guilty of the lower grade. If the jury has a reasonable doubt as to whether the defendant, Natalie Page Cochran, is guilty of any offense, the jury must resolve that doubt in favor of the defendant, Natalie Page Cochran, and find the defendant not guilty. Evidence relating to any statement alleged to have been made by the defendant, Natalie Page Cochran, outside the court and after a crime has been committed should be considered by the jury with caution and weighed with great care. All such statements should be disregarded entirely.
It was involuntary manslaughter. That's why you see the wrong one.
Unless the other evidence in the case convinces the jury beyond a reasonable doubt that the statement was made knowingly and voluntarily. In determining whether any alleged statement
I heard it as
made by the
involuntary.
defendant, Natalie
It could be
Page
voluntary.
Cochran, outside of court after a crime
Then
has
I
been
blame
committed
Jamie.
was knowingly and voluntarily made, the jury should consider the age, training, education, occupation, and physical and mental condition of the defendant, Natalie Page Cochran, and all other circumstances surrounding the making of the alleged statement. The jury may give the statement such weight as the jury finds it deserves under the circumstances. The test for the burden of proof in a criminal case is beyond a reasonable doubt. This means that after considering all of the evidence, if you have a reasonable doubt of the accused's guilt, then you must find her not guilty. You must always remember there is no burden upon an accused to prove anything. It is the state who has the burden to prove the accused's guilt. One never has to prove one's innocence. You must give an accused person the benefit of any reasonable doubt you may have from the evidence or from the lack of evidence, but remember the doubt must be a reasonable one. This means that it must be founded on reason and should be explainable, not a dreamed up or fancied one with no basis. The test is not beyond a shadow of a doubt, nor beyond all possible doubt. It is beyond reasonable doubt. After hearing and considering all of the evidence, you are satisfied that based upon the evidence you have in your heart an abiding conviction of the truth of the charge, then you are convinced beyond a reasonable doubt. It is your duty in this case to apply the law as given to you as a whole in the form of these instructions to all of the evidence in this case. In that regard, the court has instructed you on your role in determining the credibility of a witness and the weight of the evidence. The court has instructed you on the difference between direct evidence of a fact to be proven and circumstantial evidence of a fact to be proven. You must never convict a person unless the facts justify it, but you should not shirk your duty when the facts do justify a conviction. You must require that the state meet its burden of proof, but you must not make the state's burden an impossible one. The burden is always on the state to prove guilt beyond a reasonable doubt. This burden never shifts to the defendant, for the law never imposes upon a defendant in a criminal case the duty of calling any witnesses or producing any evidence. A defendant is never to be convicted upon mere suspicion or conjecture. To convict, you must be satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. So if the jury has After a careful and impartial consideration of all of the evidence, a reasonable doubt that the defendant is guilty of the charges, it must acquit. If the jury views the evidence in the case as reasonably permitting either of two conclusions, one of
Everyone
innocence
balanced.
and the other of guilt, the jury should, of course, adopt the conclusion of innocence. In the trial of a criminal case by a jury, the law contemplates the concurrence of 12 minds and any verdict returned, whether guilty or not guilty. Each individual juror must be satisfied beyond a reasonable
Juror.
doubt of the defendant's guilt before he or she can consent to a verdict of guilty. If each and every individual juror has a reasonable doubt of the defendant's guilt, you must return a verdict of not guilty. The jury is no place for unreasonable pride of opinion or for stubbornness. While no juror should yield a conscientious opinion deliberately formed after a full and fair investigation of the case, nevertheless, it is the duty of every juror to consider all of the evidence of the case, the instructions of the court, the arguments of counsel, and to discuss the evidence with the other jurors with an open mind and to give careful consideration of the views of fellow jurors. And if it can be done without sacrificing conscientious conviction, agree upon a verdict. Ladies and gentlemen, that concludes the reading to you of the court's charge or the instructions of the law. We're going to take a very brief recess so that the attorneys can collect their thoughts.
Yeah, those jury instructions, just as they always are. We zoned out, they zoned out, everyone zoned out. They lasted, I don't know. Now we're getting ready for 45 minutes of closing from the state, followed by an hour from the defense maximum, and then 15 minutes maximum rebuttal from the state. I think the defense, in my opinion, have to say there is no concrete evidence. We know all of this is circumstantial, but what is the evidence that she injected him and that he even was injected with insulin? They want you to rely solely on the testimony of Dr. Uribe, who said, this chart shows it's insulin. There was allegedly 13 other things that could have given the same indicators, but he chose insulin. We know the first ME who looked at the body didn't reach the same conclusion. Our experts said there's no reason why he should have reached that conclusion other than he might have been biased when he looked at the body the second time. There's no evidence that Michael was about to turn her in because of the Ponzi scheme. She has taken full responsibility for her Ponzi scheme. She knows she's a bad girl. But sadly, this is a desperate state that wants to imply malice where there is none. Michael was a sick person. We know that. He had a long history of illness. He didn't want to go to the hospital. She didn't want to have the argument because, as you also heard, he can get quite combative. She waited too late to get him to the hospital, and she will regret that till the day she dies. But she never, ever injected him with insulin. The only reason the insulin was in the house was because she was the emergency care person of the neighbor. The state hasn't even proven it was insulin poisoning. Hasta la taco, we give the donuts. Yeah, if it's the turtle guy, I'm out of here. Yeah, and he was under professional care. Not one person at the hospital had any inclination that it was insulin poisoning. This is the state coming back trying to say, if you're a thief, you're a murderer. Our client is a thief. She has embezzled money, but that doesn't make her a murderer. but I'm afraid they are going to bungle it up. They're going to talk for hours about non-existent evidence and his physique. I wouldn't even go into the bodybuilding. I would just say they haven't proven, and I would keep it short and just leave it to the. Let's see where the state is going with it, because the state is going to spin a yarn about Ponzi schemes and, well, she canceled a meeting, and if she had gone to that meeting, Michael would find out there's no money there. But Michael was sick. She was sick. She went to the doctor the same day. There's no reason why she should go to Virginia to sign papers. She was sick that day. We know it from her treating physician. Well, typical kids, just ruining all the fun. It's up to the jury to discern, but again, you have to put all the reasonable doubt in their head. Yeah, as long as you keep it short and to the point. We've all seen that where he stands up and say, please don't be too harsh on my guy. Yeah, if they couldn't rely on the financial crime to prove she's a bad person, what would be the evidence of this? No one would have looked twice at this case if it wasn't because of the financial crimes. And I don't even know why they all of a sudden believed that she killed him. I know that there might be something in the financial case that could imply it, but there's just seems like a lot of work for nothing. No, it's not an unpopular opinion. Remember, there's no popular or unpopular opinions, and we always go by the state must prove it. And what happened in that house, I don't know. I just know that I don't feel the state have proven it enough that I would send her away from everything from 10 years to life. I couldn't do it on the basis of what we have been presented here. But I've also seen a lot of trials from the US where they don't care. I still think the biggest injustices we have covered is the Cara Rentala case. Luckily, they got her on a lesser included, so she'll be out sooner. And I still think Nicholas Mew got the wrong end of the stick. And Jamie, what's his name in New England, New Hampshire, New Delhi? The guy who put 7 new holes in another guy. I think all of those were injustices. But what do I know? I ain't no lawyer. I'm just pretending to know stuff on the lines. Boom, 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 boom. Thinks she's guilty of not taking care of him. She should have taken him to the hospital from the evidence heard, but that is all that have proven to me. Yeah, and that could get you to involuntary manslaughter and a year.
All right. Are there any matters that we need to raise and discuss out of the presence of the jury at this time?
There's one that's been brought up by the defense, Your Honor, and that is the indictment says February 6th. The
Indictment actually says February the 11th.
That's what I thought it said too, but I was told by the defendant and I didn't have a copy.
Well, I've got a copy because I heard the same suggestion that you did, and it says on or about the 11th day of February, 2019.
Blaine Selden, he came up with it.
Just the point I brought up, and it's probably too late to address it. The murder says February 11th. The alleged act occurred on February 6th. That's when the alleged act occurred. The death of Cochran occurred on February 11th. I don't know what we can do about it or anything of that nature.
It's on or about. There's nothing to do about it.
I don't think there is anything we can. Oh, We didn't have a court reporter.
Well,
Uh-oh.
I
You
thought
want
you
a
were
record
down
of
there,
that, go ahead.
Joanne. I'm sorry.
No, you didn't do anything wrong.
You didn't do anything wrong.
Always
All
blame
right,
the
I think
secretary,
we can
just
go
like the
forward.
doctor.
We can change the instructions and I can read them all over again, but everybody's moaning and groaning and nobody wants to hear that.
With a big sign that says, "This is Selden's fault."
Right.
Just for the sake of the record, I brought to the court's attention, the indictment says that the murder occurred on or about February 11th. I just brought to the attention of the court, the alleged act occurred on February 6th. The passing of the deceased occurred on February 11th. I don't know how that impacts anything.
I don't think it impacts anything. It's on or about. No objection was raised. You all approved the jury charge and we're going forward.
Thank you.
All right. Are you folks ready to deliver your closing remarks?
Yes, Your Honor.
Bring in the jury, please.
No, it's again, yeah, maybe technically, but they can probably add that. Welcome back, Gina Gomez. Remember to get your bingo, bingo, bingo. Get ready. The jury's coming in. Bingo, bingo, bingo will start very, very soon. Finally, we will have closing arguments starting
All right, ladies and gentlemen of the jury, as I have alluded to, the next stage or part of this case is the final argument of counsel. You will hear from each side, and the attorneys will argue the issues and the evidence presented, giving you their own interpretation of that evidence. As I've said over and over, their remarks would not be evidence themselves, but all of these attorneys have worked very hard in presenting this case before you, and I ask you to please give them due consideration. We will follow the same order that we have established in this case.
Good luck.
As you
on
know,
the
the
bingo,
state
bingo.
does have
You
the
can
burden
win
of proof,
stickers.
and we'll go forward first. Then the defense will present their
Yes.
entire argument, and the state has a brief period to rebut. All right, Ms. Acord, you may proceed. Okay.
Good afternoon, ladies and gentlemen of the jury. As you know by now, my name
I'm sorry to say it, but she looked like Kate Peters if Kate Peters had a shower.
is Ashley Akerd. I'm an assistant prosecuting attorney here in Raleigh County. I've been presenting this case to you with Tom Truman, who is our current prosecuting attorney. We're here in the matter of State of West Virginia versus Natalie Cochran. And if you all will bear with me, I will have to do some reading as we go. There's a lot of ground to cover here, so.
If you shut up, didn't do that, and just get going. It's kind of like those people when you go into a YouTube channel and they start a live show with a 15-minute video of stuff that has nothing to do with anything. Just start.
The first thing I want to do is thank you for being here. Just very briefly,
No, don't thank them. They are not there because they want to do it. They want to go home. They hate you. They hate this courtroom. They hate this case. The only thing that made these people happy the last week is the judge. So instead of doing all of this, oh, I have to be friendly with the jury, remember the only thing everyone should remember.
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
I know everyone does this, but this has been a long couple of weeks, and we've
Yes.
had a lot of evidence come in this case. So just thank you all for sitting through it with us. Thank you for being here, and thank you for deciding this case.
They haven't decided it yet.
Now, at this point, you all know why we're here and what we've been doing for the last few weeks. My job today is to prove to you beyond a reasonable doubt that this woman, Natalie Cochran, feloniously, willfully, maliciously, deliberately, and with premeditation killed her husband, Michael Cochran. This entire tragedy can be summarized into 3 different blocks of time. September 29th of 2017 through August 26th of 2018, September 1st of 2018 through January 30th of 2019, and January 30th of 2019 through February 6th of 2019, the week that Michael falls ill for the last time. Now, Michael Cochran was 38 years old at the time that he died. He was a father, a husband, and a son. He was a very fit and healthy man. He cared a lot about what he looked like and a lot about what people thought of him. He lived and worked here in Raleigh County. As you've heard, he worked in technology. He also worked with Workforce West Virginia. Ultimately, he was a minority partner in the Business Tactical Solutions Group, in which his wife, Natalie Cochran, was the 51% majority owner. And we'll just briefly talk about TSG. We don't have to get too far into it, but I feel like we need to cover that ground again. TSG is represented through its website to be a leading supplier to the Department of Defense, national security agencies, federal civilian agencies, prime contractors, and nonprofits worldwide.
Yep.
And we've heard a lot about how the business ended up not being super legitimate. In fact, it wasn't at all.
We just started.
But it originally was set up that way. They had filed with the Secretary of State. It had a business license, and it actually was registered with the federal government to bid on government contracts and to be awarded those contracts. It was held out to be a woman-owned small business, which gave it priority in getting contracts. But a business like this required one thing: startup capital. There was 2 ways that the business attained startup capital, and that's the money that's needed to get it off the ground and get things running in general. The first way was through investors. And what would happen was Natalie would go to her friends, her family, people in the community, ask them to invest in this company. They were promised a return on their investments when contracts were ultimately fulfilled. They'd get more money back than what they put in.
Over under on the amount of time will be spent on the financial crime, not on the red rubbing. I bet 75% of her closing will be she's a bad person, she steals money.
And sometimes when the money would come back, she would ask them to invest again so they could get an even higher return on their original investment. So some of these people were putting money into this company over and over and over again and seeing very little payout, if any. The other way that TSG gained startup capital was through loans. She would apply for small business quick capital loans. And what that means is these were rescue loans. These were for companies that were in trouble. They would have a very high interest rate, and you would have to pay back on them daily. And now I'm not saying that Michael didn't know about investors and didn't know about loans. He knew people were investing. He knew there were loans. But they weren't what he thought they were. Some of the loans, he was told, were SBA grants. What's so special about a grant is that you don't have to pay the money back. That money is given to you for a specific purpose. Otherwise, he thought they were getting government bonds. Specifically, Natalie held out the loan companies to be factoring companies. And what factoring companies do is they buy all of these accounts receivable that you have, and they'll pay you for a portion of them, and then they'll collect the money later. So that's what she told him was going on. So what happens next is about August 26th of 2018, Michael really discovers the extent of family investors and investments. You heard that he got into Natalie's phone at one point and read her messages, and that's how he found out. He was completely unaware of the lucrative returns and profits that were being promised to people. He was quoted as saying she was giving away our money. On August 27th of 2018, Natalie sent a message to a few family members, which we've put in evidence and you all have seen. Hey guys, after the contracts that are out pay off, I will have to stop subcontracting. I wasn't as transparent with Michael as I should have been. After this, Michael and Natalie made rounds to family members trying to pay some checks, try to pay some people back. But ultimately, Michael realizes that the amount of money that they owe people is a lot.
Which could also mean I wasn't as forthcoming with how much I was going to pay you guys for investing.
More than he knew. So now he wants to be more involved and understand how everything works. On August 27th of 2018, Natalie sends Michael this message, this series of messages. 3.45 million should post tonight at midnight. 300,000 should post Wednesday. 1.25 million on Thursday. 724,000 Monday of next week, and 2.56 million next Friday. You've heard that Michael was spending money. This is why. This is why he was so charitable. You heard that he donated a weight room to a middle school. He bought uniforms for youth sports. He bought a house for a youth pastor who had nowhere else to go, and later rented that house out to Chris Davis's recently widowed aunt. He was trying to give to people. And he'd been led to believe that this legitimate business was thriving and all of this money was due to them. She set a prize date, though, when she did this. All their hard work was going to start paying off at midnight. So what did this ultimately do? It created a big problem. It created a bunch of promises that Natalie couldn't fulfill. And those promises totaled, at this time, $247,499,232. So in our next time frame, Natalie starts to claim that the government is conducting an audit of TSG. And she uses this as a reason that they can't pay money to investors, a reason they can't get contracts, they can't get paid on outstanding contracts, and the reason that they're not seeing any returns. So she solicits 2 more investors. One of those was Chris Davis. He told you about that. She obtains 3 more rescue loans. On October 25th, Natalie tells Michael the audit is complete. We're going to have our money October 29th.
Is monies a word? All monies available. Is monies a word? I never heard that before.
Michael, the audit is complete. We're going to have our money October 29th. So what happens right around that time? October 31st.
What was the word you didn't like last week, Brandon?
First, Michael goes to the hospital. He's expecting $248 million on October 29th. The money isn't produced. On October 31st, he's sick. He goes to the hospital.
I had an English teacher that said you can never ever spell money with an I. But maybe it's British or something.
And he gets discharged, but he's not well. He's not better. And the defense would have you believe that Michael was incredibly sick all the time, that he left the hospital, went back to the hospital because he got sick all over again. No, he was sick one time. He just didn't get better. It happens. It happens all the time, all over the world. When Michael went back to the hospital on November 2nd, Natalie reported that he had had a seizure. That was never confirmed. You heard experts testify that the seizure activity in the records was reported by the defendant. Everyone else who testified said they had never seen him have a seizure. At that time, he had his friend Chris Davis take him to the hospital because he wanted to be treated. Nobody wants to feel the way that Michael felt.
We weren't allowed to speak
other than
American,
this,
only English.
He was healthy. You would think that he was sick, though, because he was stressed out of his mind, because he was waiting for $248 million that had been promised to him that he hasn't seen. But it still isn't coming. And there's a whole lot happening during this time. A phrase that we've been throwing around a lot on our team is that Natalie Cochran involved everyone and included no one. So on December 4th, BB&T is closing the Cochran's accounts. Michael goes to BB&T, and you've heard about that. He is irate. In fact, his friend Chris Davis is called to come down to the bank because Michael is causing such a scene that there is fear the police are going to be called. He's angry because he thinks these accounts closing is why he's not seeing any money. So ask yourselves, if Michael was involved in a felony level financial crime involving hundreds of thousands, at this point, hundreds of millions of dollars, why would he go cause a scene at a bank and potentially get the police called on him? He didn't know what was going on. And this is where Natalie gets lucky for the first time. On December 6th, the government's already partially shut down and is only funding certain departments. I'm sure we all remember the government shutdown because it was a really big deal and a lot of people had a really hard time because of it.
I don't.
On December 22nd, the entire federal government shuts down. So we've gone from an audit to a federal government shutdown, buying her more and more time. And the shutdown becomes the reason that they're not getting paid. Now, Natalie has told Michael and all the investors that the money's frozen because of an audit. Now, the government's shut down. Next, she tells people she has cancer, chronic lymphocytic leukemia, which we talked about that a little. We've never found anything that indicates that that was real either. She now has to deliver. So she tells Michael and she tells the investors, on February 1st, the federal funds will be released because the shutdown has ended. So why does the money come in on February 1st? It's January 30th of 2019, and we have entered the week of Michael's illness and ultimate death. So here is where she gets sloppy. Her motive to kill him becomes very clear because he is very quickly catching on. It becomes very obvious who's been running the company, that Michael has no idea about the Ponzi scheme. And more importantly, we're seeing that Michael's about to discover the truth of everything that's been going on. So she has two choices. She can come clean, or she can go into self-preservation, which requires that she take him out of the equation and make sure he never finds out what was happening. January 31st of 2019. Natalie says, I'm on the phone with Bank of America. Michael says, are we 1,000%? Yes, she's sending them with tracking. Money is supposed to hit tomorrow. February 1st of 2019, the fund release date told to investors and told to Michael, no funds hit any accounts. This was a Friday. So Michael knows at this point, Monday is the next day he can do anything. So on Monday, money isn't in there. More excuses. Michael is getting increasingly concerned. Later that same day, she says that she spoke with the wire department. All of this money is about to come through. 4.8 million in the morning, 23.8 tomorrow sometime. Michael says, shit, can't do anything today. Michael was just like the rest of us, as you can see. Doesn't make any sense. I certainly don't think it makes any sense, ladies and gentlemen. And that's because nothing he was told was true. So let's get into Michael's murder. February 4th of 2019, Natalie sends Michael a text message. I'm at the pharmacy. Need anything? Now, if you'll recall from Dr. Halsey's testimony yesterday, on February 4th of 2019, Natalie was picking up her prescription for Xanax, which Dr. Halsey also testified is a benzodiazepine. Michael is allergic to benzodiazepines, as you've all heard. On February 5th of 2019, Natalie goes to Access Health and sees Dr. Halsey with flu-like symptoms. She says she's vomiting, she reports a fever. She's negative for the flu and strep. She got a steroid shot and labs that day. Now you'll note that this is the doctor who, she said, put her on such a high dose of steroids. That was her words, high dose of steroids. As we'll later see her tell Jennifer Davis. But he didn't give her a prescription for insulin. And you heard his testimony yesterday that he didn't instruct her to get insulin. On this day, she also requested methylprednisolone from Stephanie Hamilton. And we all know that is Solumedrol.
No, we don't all know that's Sodrometrol. I don't know what medical degree you got connected to your law degree, but you're kind of making me feel like I'm an idiot because I don't know it.
And if you'll recall, a vial of methylprednisolone was later recovered from the Cochran residence when the search warrant was executed. FBI analysis told us that that bottle had never been used.
But you said she got an injection. That has nothing to do with it then. You know
same
everything,
day,
Brendan. Irregardless
Natalie
of that,
reaches
I
out to
don't know it.
Albatross Air, the Kearns family, and schedules a flight for her and Mike to take the following day to Lynchburg, Virginia. We've heard a lot of talk about that flight. You heard from Court Nexon, who is a former Bank of America employee. And he told you that the Cochran's account was never funded. There was never money in their Bank of America account. Mike couldn't understand why. So sure, they were going on this trip to fill out signature cards and things like that. But they were also going to find out why contract funds weren't posting to this account, why all of these wire transfers we've heard of were not coming through. And if they went on that trip, it would have changed everything. So on February 6th of 2019, the last day that anyone sees Michael Cochran conscious, 6:34 a.m., Natalie Cochran texts Chris Davis. She tells him she can't go to Lynchburg because she has a fever of 103 degrees. Now you'll recall she asked Stephanie Hamilton to bring a thermometer over because she apparently didn't have one. 6:35 a.m., Natalie texts Josh Kearns at Albatross Air, cancels the flight to Lynchburg because she has the flu. Mike tells Natalie to tell Court Nexon and his boss that they won't be there today because she's sick and they'll come tomorrow. But if they still need him to come today, Mike will go.
I might need
He'll
some
take
of
his
those
friend
blue
Chris
pills, if
Davis
you know
with
what I
him.
mean.
They'll come back and get her signature card notarized. Mike very much wanted to take this trip. 6:37 a.m., Mike tells Natalie to get Court Nexon to wire them $5,000 to $10,000 from their account. The account that is still sitting empty at Bank of America. Natalie tells Mike she's already canceled the flight and he tells her to reschedule it for the next day. And this, ladies and gentlemen, is the text canceling the flight to Lynchburg, wherein Natalie says that she's been up all night with the flu, which we all know she was never diagnosed with. Later on February 6th, she sends.
How many of you have self-diagnosed yourself with the flu and you take 3 days on the couch and sweat it out and go? I don't think I've ever gone to the doctor with a flu. And I'm a man. Every man flu is essentially deadly.
This text message to Michael. I'm in the doctor's office getting swabbed again, getting a Prometh shot, getting you and I both meds. Now Mike is
Well, I
currently
get
out and
man
about
flu,
in
not
town.
women flu.
He goes and gets some Starbucks at 8:37 in the morning. Natalie arrives at Access Health at 8:10. She says she's getting them both meds. Now you heard Dr. Halsey testify yesterday. He didn't see Michael that day, and he did not prescribe anything for Michael that day. In fact, the only medications that Natalie was prescribed that day were promethazine tablets. Promethazine, which Michael is critically allergic to. So what did she tell him that she got him? And isn't it interesting that Natalie Cochran runs straight to the doctor at the first sign of trouble? Frequently. But let Michael Cochran lay on the couch for 6 hours, unconscious. And let's ask ourselves how Michael was feeling around this time. Well, you remember Jason Bowen telling you he, quote, felt like he was being poisoned. She later texted.
So she poisoned him before, and then she poisoned him again because he felt poisoned before this happened, and now
Jennifer Davis, we are both sick. So they put me
I
on
think that
such
most of us
high-dose
believe she'll be
steroids, I
found
have to
guilty,
start
but
taking
it's not
small
proven.
insulin shots. Gonna have to order a vial. Again, there's no records that support any of this. There's nothing that indicates that she needed insulin for any reason at all. And if Mike was really keeping insulin in the house for his bodybuilding that everyone keeps talking about, why couldn't she use that? Why would she need to get it somewhere else? And I'll also add, the last text between Michael and Natalie Cochran is at 8:51 a.m. on February 6th. Following that was a 15-second call at 8:52 a.m. And this is the last time we know of that they spoke with each other. Later on, as we all know, Jennifer Davis offers up a vial of insulin because she's a good friend. She's worried about Natalie. She thinks her friend has cancer. She thinks that she's dying. She's doing everything she can to help. So she offers up her own son's vial of insulin. Natalie sends another text to Jennifer Davis. Mike's sick today too. He didn't get anything prescribed for him. He didn't go to the doctor. All that we've heard is that he laid on the couch for a couple hours. Chris Davis shows up a little while later, and as we all know, drops off a bag, which he testified that he never looked in. His wife, Jennifer, told us exactly what was in the bag. Some Propel,
it's in the
the Diet
bag.
Coke that Natalie asked for, and a brand new, unopened vial of Humalog insulin. Jennifer says, "You're welcome, but that's nothing. I sure wish I could do more for you." And Natalie's words are, "That was perfect." And I bet it was. Another message she sends Jennifer Davis. Mike was so mad this AM about not being able to go today. He had to take 2 of my blood pressure pills. Now, the last documented communications from Mike's phone,
But she didn't. say God.
11:15 a.m., John Hamilton told you he called and didn't get Mike. He leaves a voicemail message. 1:39 p.m., which you heard testimony today, we believe Michael was unconscious at that time. A text goes from Michael's phone to Matt McCormick. "Should be good, buddy. I'm available all weekend too. Whatever works best." "12:29 on February 6th of 2019, Natalie Cochran takes this photo of her husband, Michael, laying in their kitchen floor. Now, ladies and gentlemen, I don't know about you, but if my husband had a serious medical event and was lying unconscious in my kitchen floor,
He's only
I wouldn't be
been going
taking
for 20
pictures
minutes.
of him. I'd be getting help. The first person she sends it to is her sister Penny, who testified that her reaction was, "Well, what does she want me to do about it?" And I think we all know the answer to that question. Next, she reaches out to John Hamilton, who you heard testify a few days ago. She tells him, "Mike is sick like last time. Last time when he asked to be taken to the hospital. Last time when he wasn't left unconscious in his kitchen floor." John heads that way, and Natalie then calls her private
That was his
contractors, Jason
blood
Bowen and
glucose
Jonathan
number
Miller,
when he was
to come to the
admitted.
residence and help. You heard Jason testify that they were at Lowe's at the time. The story he was given was that Michael threw up in the sink and then used the kitchen cabinets to lower himself to the floor. Jason and Jonathan arrive and they move Michael to the couch. And Natalie begins reading them vital signs that they can't see. That includes his blood sugar. Why would you check the blood sugar of someone who doesn't have diabetes or any known problems with regulating his blood sugar? Ladies and gentlemen, I'll posit to you that
Do we have a bingo? We might have a Kiki K bingo. Kiki, put in the number on top of your bingo card so we can check if you are the lucky winner. Inner. Bingo card 167. Kiki K has called a bingo, bingo, and Kiki was her name. Oh. Jemima just put up all the words. Do we have a confirmation? Confirmation. Or will the dastardly Jess crush her hopes? You're so mean. I don't know. It depends on how late we end. Well, then you have to stop being that good at bingo. Mm-hmm. Jemima is probably on the throne. Doesn't have time to check it. See you, Celestial. Boom, 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 boom. Confirmation. Confirmation. Checking it and no bingo. It's missing a few words. Remember, it's a X or a full bingo. False alarm, everyone. Everyone is still in the game. It's still in the game. So if you missed the words, scroll back up. Jedi just have the words put in 2 separate messages. We will keep going. Owen. What about Brandon's? Did Brandon call a bingo? Brandon claiming bingo 060. 060. Crispy Bacon, how long have you been following this channel?
if he were just sleeping it off like she wanted him to do, he would have felt that finger stick. I've had 100 finger sticks. I know what they feel like. You're not going to sleep through that. At that point, she reports that his blood glucose is 145, and this is at 1:06 p.m. John Hamilton shows up shortly after that, maybe 20 minutes after she contacted him the first time. He told you that Michael was already laying on the couch when he got there. He immediately asks, how are we going to get Michael to the hospital? Natalie's response is to let him sleep it off. She now tells him that Michael was sick and had a seizure. John noted that he had never seen Michael have a seizure. John then contacts his wife, Stephanie, who is a physician assistant, as you all heard. He asks her to come over and, quote, get her to take him to the hospital. So Stephanie arrives a little later and takes Michael's temperature. She made it a point not to startle him and even warned him that she was going to be taking his temperature. But he doesn't wake up. Stephanie also tells Natalie that Michael needs to be evaluated. Natalie again declines and says Michael wouldn't want to wake up in a hospital. Stephanie even gave her an out. She said, he can blame me. Also, at some point during the day, Natalie and Mike's kids come home from school, and Natalie's sister, Penny Lowry, arrives. Penny told you that Michael had an accident, and she held a blanket up while Natalie changed him into dry clothing that was retrieved by Natalie and Michael's daughter, Nicole. Thomas Treadway shows up later. When asked if he believed Michael needed to go to the hospital, he told you he's not a medical professional. Natalie's text messages indicate otherwise. They indicate that he believed Michael was getting worse and that he needed to be checked out. So you decide. At 4:34 p.m., Natalie reports that Michael's blood glucose is 115. She tells others that Stephanie Hamilton took that reading, but Stephanie Hamilton took the stand and told you that was not true. Lastly, Chris Davis, Michael's best friend by all accounts, arrives at the residence. He told you how he ran his thumb up the sole of Michael's foot to see if he could startle him awake. He told you that he tried a sternal rub. Nothing. His words to you were, he is going to the hospital, and I'm going to take him. At that point, he and Thomas Treadway load Michael into the back of the Cochran's car, where Natalie rides with him as Chris drives him from 4H Lake Road to Raleigh General Hospital. When Michael arrives at Raleigh General Hospital, his blood glucose was 21. That's a far cry from 145 and 115.
That's the 21 you looked for.
Seemingly, it's plummeted out of nowhere. You heard from Dr. Uribe and Dr. Krieger. The only reasonable explanation is exogenous insulin administration. And ladies and gentlemen, the defense has posited to you that if Natalie Cochran injected Michael with insulin, whoops, dropped the needle. Here's the good news, I brought it back up. He would have felt it. Now, this is an insulin needle.
You know, I'm going to object to this demonstration. This is bringing outside the evidence before the jury.
This is a demonstrative exhibit, Your Honor.
Overall, it is a demonstrative exhibit used in closing arguments. Members of the jury, you are the judges of the evidence. This is a demonstrative exhibit. I want you to rely upon your recollections and your memories of what the evidence has been in making your decision. There's a certain rough and tumble that we allow and some latitude in terms of closing remarks. I'm going to, as I say, overrule the objection and permit counsel to proceed.
Thank you, Your Honor. Ladies and gentlemen, I want you to see the size of an insulin needle. That needle I just showed you holds 30 units of the kind of insulin that Gavin Davis was prescribed and that was received by Natalie Cochran from Jennifer Davis. Dr.
What? Was that it? Why didn't you parade it in front of the jury and show it off and made it a little more theatrical? I know I'm a barely passable grifter, but at least I know sometimes you put a little showmanship in it. Use your town crier voice saying, "This is like the amount he reasonably must have gotten." There's no way she knows how much insulin he was given. So 30 units, I don't care. I would have put 100 in there and said, this is maybe the same amount they were giving him. Look at this amount. This is legal by all accounts.
Krieger told you how small a unit of insulin is, and you can see it for yourself. Extremely small. I would also say, we made it pretty clear yesterday that the defense experts did not have the full picture. They had incorrect and incomplete information, so how could they make an informed opinion?
They had all the medical
When
records.
Michael arrived at Raleigh General, as I said, his blood glucose was 21. He was immediately intubated, and he never woke up. February 7th through 11th of 2019, Michael was transferred to Charleston Area Medical Center, CAMC. His MRI there, as you've heard, showed diffuse hypoglycemic encephalopathy, brain swelling caused by low blood sugar. February 10th of 2019, Michael is transferred to hospice care at his wife's request. He spends 5 hours there before he dies. Now, you'll recall during Thomas Treadway's testimony that he advised Natalie needed to remember that she took his vitals that day and that she needed to make a timeline of the events leading up to Michael's death. Why? Here's some of the different stories she told. Michael was sick in the sink and fell. Michael was sick in the sink and lowered himself to the floor. I heard him hit his head, and when I went in there, he had fallen. She also said he was vomiting in the sink, had a seizure, and then hit his head. And that's just a few of the stories we heard. Now, a search warrant of the Cochran residence was executed.
Yeah, but still, show it around. It's a demonstrative. You can BS it up all you want. I would have brought in the big one, the one you use to drain spinal fluid, and say, this could have been the needle she used.
On June 25th of 2019. And I would note that TSG has continued business up to this point, even getting additional investors after Michael's death, including the Hamiltons. During this time frame, Natalie also pled guilty to the charges that you heard about in federal court, the wire fraud and unlawful monetary transactions.
Remember to talk
During the
about
execution of that search warrant, a lot of things were found and taken from the Cochran residence. Of note for us was the unopened methylprednisolone vial and the insulin that she kept in her refrigerator. Now, if you remember when Lieutenant Bledsoe testified, he told you that when he reviewed the property receipt from the search warrant with Natalie Cochran, she flipped through it and immediately went to the insulin. And she said, I keep that for my neighbor's son who has diabetes. Ladies and gentlemen, as I stated previously, the elements of first-degree murder are a felonious, willful, malicious, deliberate, and premeditated killing.
4 more minutes.
Felonious is simple. Murder is a felony, and it's against the laws of the state of West Virginia.
She's going to be found
Willful
guilty.
or deliberate would mean that someone took an overt action in furtherance of an anticipated result. She injected Michael with insulin. Dr. Krieger and Dr. Uribe testified that there was no alternative reasonable explanation for Michael's blood sugar to be 21 other than outside insulin administration. She also let him lay on the couch for 6 hours. She brought in all this help over and over just to refuse it. Malicious, showing or having a desire to cause harm. Natalie was a diabetic counselor and a pharmacist. She knew that injecting insulin into a non-diabetic would cause harm. She chose over and over, after repeated pleas from friends and loved ones, to leave Michael on the couch, laying in his own urine. She also showed a complete indifference for human life when she continued to work on contracts and make plans for bingo while her husband lay dying in the hospital. Premeditation. She obtained the murder weapon in advance from Jennifer Davis.
Welcome back,
Poor
Kim.
Jennifer had no idea what she was getting herself into when she did that. She had a clear motive, and you saw that leading up to this date, Michael was about to find out what she was doing to people. Do we know what he was going to do with that information? We never will, because he won't have the chance to tell us. Michael was killed because following the actions of the defendant, he was admitted to multiple hospitals and ultimately passed away at hospice. Well, there's a couple of defense theories that I just want to go ahead and debunk while we're here. The first being, Natalie was a pharmacist and could have gotten undetectable drugs to kill Michael. Those were defense counsel's words. She did, just not as a pharmacist. She hadn't worked in pharmacy for 2 years at that point. Insulin can be bought over the counter. Stephanie Hamilton debunked this one. She testified that Humalog, the kind of insulin that was used to kill Michael, cannot be bought over the counter. And how
no, defense never said she could have gotten it. Someone implied that she could have, and I think it was a state witness who implied that she could have gotten it because she's a pharmacist.
has to be obtained via a prescription, which neither Natalie nor Michael had. Michael was a, quote, ticking time bomb. Michael's previous illnesses can only be verified by Natalie. No one else ever saw him have a seizure. Sure, he went to the hospital, but they were never actually able to verify that seizure activity occurred, only that it was reported at home. By her own words, Mike was doing the best he had ever done in his life. You heard testimony that he forgot where he parked his car. Ladies and gentlemen, I don't know about you, but I forget where I park my car all the time. It's very common.
No, it's absolutely not very common to forget where you park your car. I'm a 27-year-old man who might be in a slight mental decline because of my age. I go to a gym in January where all the weirdos are in there because they only need to train the first 2 weeks of January and the last week of May to get the body they want. So every day the parking spot is filled. So I can't park where I normally park. To this day, I haven't had any problems finding my car. I can go to the supermarket and park. I can find my car. It's actually not that common to forget where you park your car. At least not with people I hang around with. Maybe it is for her, but would you trust her to run a criminal case if she can't remember where she parked her effing car?
He participated in tough man competitions and Jeep pulling competitions. It doesn't sound like a sick man to me. You also heard that Michael was on steroids. Chris Davis testified that Natalie told him that she was in charge of all of his supplements and vitamins. No steroids were recovered from the Cochran residence when the search warrant was executed.
Yet, I don't know. You all know. I for one, respect all genders. Don't believe there's any differences. Maybe it's a lady thing. Jamie can't remember where her driveway is. If I've been a place twice, I don't look at the GPS anymore. I've been there before. I know how to find it again.
The Mexican supplement that we've heard about turned out to be a female fertility drug that came from Florida. You know who had communication with that company? Natalie Cochran.
No, because I'll just look at the number before I go in. If it's a new place, like I was in IKEA in Switzerland, place I've never been before, I snippety snapped where I was parked. No problem.
Ladies and gentlemen, in closing, Natalie Cochran had the means, knowledge, and opportunity to commit this crime. She dosed Michael Cochran with insulin that he was not prescribed and that he did not need. You may not have done the math, but I have. Next Thursday will make 6 years to the day since she injected Michael Cochran with insulin in his home.
You still haven't proven she injected him
5
with
days
insulin.
after that will be 6 years since Michael Cochran left this earth. 6 years since 2 children lost their father. 6 years since this woman, Donna Bolt, and this man, Ed Bolt, lost their son. 6 years since they were able to see him for the last time.
I think everyone knows insulin, but how many didn't know that insulin can be used for bodybuilding?
Michael and the people that loved him deserve to have the most thorough investigation that we could conduct. And we've done
just
that.
Take a photo of.
We've
where
done
you're
everything
parked.
we could to show you what really happened to Michael. These people have waited long enough for justice. Michael has waited long enough for justice. Ladies and gentlemen, I'm asking you at this time to deliver that justice and to find his wife, Natalie Cochran, guilty of the first-degree murder of Michael Cochran. Thank you.
So, let's do a poll. Did state closing convince you of guilt? Just to have a poll, because everyone hates when they go into a YouTube channel and they have, did you remember to hit the like? No, well, I won't do it if you ask me all the time.
Mr. Vic,
Kind of like when my ex-wife said, did you remember to empty the dishwasher? Don't you pressure me, woman.
Victor,
Well, they didn't look at the body till 7 months later, so.
Counsel for the state, ladies and gentlemen of the jury.
I don't think we have had brain damage. But Jemima puts up the words every now and again.
About 2 weeks ago, when I stood in front of you, I told you a couple of things about this case. And one was that Natalie Cochran was guilty of financial fraud, of financial shenanigans, and that she was indeed guilty without any reservation. But we're not here today to retry that case. And everything that the state is telling you about Natalie Cochran, yes, let's shed some light.
That was me, sorry.
Thank you, Judge. Everything that we've heard about this financial case from Natalie's standpoint is true. She was convicted. She was a participant in the Ponzi scheme. But we're not here to judge her yet again on the financial crimes. We are here to judge her on the murder of her husband. And the state cannot prove first-degree murder against her beyond a reasonable doubt. The state cannot prove three things. The case cannot prove what, the case cannot prove how, and the state cannot prove why. First question, what was Michael Cochran killed?
Yeah, we called him the Penguin from the beginning. He looks like the Penguin, Danny DeVito's version.
By, or what killed him? And you've heard the evidence over the last 2 weeks that we don't know. The experts that the state brought testified to what they themselves admitted, a definite maybe. Maybe it was the insulin shot, and maybe not. The experts that the state brought testified to, we cannot determine the objective factors, the objective anatomical findings, and tangible demonstrative evidence what killed him. They don't know. The state's expert, Dr. Krieger, said, well, the hypoglycemia due to the insulin administration is a strong possibility, but it's just a possibility. Why don't we know what killed Michael Cochran? Well, because they did not perform the autopsy. And by the time all these experts got the evidence, Michael Cochran's body was so decomposed that it is impossible medically to determine what killed him. And you heard the testimony of two defense experts. And you also heard the testimony of my compatriot, Dr. Piotr Kubitschek, who is the medical examiner who performs autopsies on a daily basis and who is, I would submit to you, a little bit like Matlock. He is the medical detective trying to detect what is the...
No.
And then...
I'm going to go back.
The state cannot answer or prove beyond Michael's death of that particular detective trying to detect what is the crime that led to the death of that particular individual. All these experts said the same thing. The cause of Michael's death is undetermined. We don't know. No. The state cannot...
I'm killing you. I didn't do anything. It was the law and crime that skipped.
Answer or prove beyond a reasonable doubt the how. How did that happen? How did this murder happen? I'm not particularly good with syringes, but, well, we'll come to that.
Don't go down the road.
The state wants you to believe that there was an insulin shot injected into Michael that killed him. But then the state also tells you that it could have been more than one insulin shot, because when Michael arrived at the hospital, his sugar level was 21. And the experts told you that it's impossible to have that type of sugar level without being pretty much continuously shot with insulin. So how did that happen? Well, let's follow the state's theory. This cold-blooded killer is planning a murder of her husband with the insulin shot. In that regard, she is calling her friend, Ms. Davis, asking for insulin on the day of the injection of that insulin. I might just as well have asked for a gun. Might just as well have asked for a murder weapon. Jennifer, I'm trying to kill my husband later today. I need the insulin, and I'm trying to kill him with insulin. I need you to bring me some insulin. Is that the action of a planning cold-blooded killer? She would get that insulin ahead of time, not on the day of the murder, and involve 2 witnesses against her right there and then, who came here to court as predicted and testified that, yeah, and they gave her the insulin. And then, how on earth did she inject that insulin into Michael? Well, let's look at these facts. Did she approach Michael from the front when he was facing her in the kitchen? And if she had the insulin injection in her hand, wouldn't he have the time to react and say, what is going on? Let's assume for a moment. Then she approaches him from the back when he's standing in the kitchen, and she jabs him either in his back or his rear end. Well, she has to have a couple of seconds to inject this insulin in him. Basic human reaction would be to turn around and face the assailant, be it his wife or be it some cold-blooded killer, a stranger. She wouldn't even have time to plunge in insulin into his body without him turning around. And he's an athlete. He's this huge guy. And here is his 5'1" or 5'2" wife who's injecting him with insulin, and he doesn't react. That's why I said it didn't happen in silence. My first reaction would be, what on earth are you doing, woman? Or whatever he calls her. What are you doing? And then somehow he drops there in a fetal position in the kitchen. Oh, that didn't happen that way. Of course it didn't. So now you heard the evidence from at least 4 or 5 witnesses that this type of insulin acts in a delayed way. 10 minutes, 15 minutes, up to half an hour. If I'm jabbed, even by my dearest wife or by somebody else with a substance, and if she is silent, that's one thing. And if she tells me, this is for you, you son of a gun, I hate your guts, whatnot, here it is, I'm killing you, I would have 10 to 15 minutes, maybe to 20 minutes, to 30 minutes.
No one will come for you, Lavender, because it's perfectly fine. We all have our opinions and we don't have to agree. There won't be a test where you will lose your right to watch on this channel if you don't agree with us. Sue is always in disagreement with me, and Jamie will call me after and say, are you stupid? So everyone has the right to an opinion on this place. We can discuss it as grown-ups.
To call 911, to run to the hospital. I told you it was 7 miles from the hospital. He would have been in the, I know it's February, but he would have been in that hospital sooner than you can say hello. Sooner than...
It was fast-acting insulin, but even the state's experts said it would have taken at least 5 minutes to knock him out.
You can slap a tick. He would have been in that hospital asking for help, an immediate sugar reaction or sugar injection to bring that insulin level to some normalcy. He wouldn't have taken it in silence. He wouldn't have just dropped down on the floor. So how did it happen? Well, the state then gives you an alternative, because now they're changing their theory. That may have happened in bed. Ah, that's a novel idea. Inject him in bed, he would not have reacted? Of course he would have reacted. He would have gotten up and he would have done the same thing. He would have taken himself to the hospital, he would have called 911, He would have probably not been particularly happy with Natalie, but that doesn't mean anything. He could have saved himself. So then the state changes the theory again. That may have happened upstairs, or it may have happened on the couch, or he's injected on the couch. Well then, okay, so he doesn't get up, so who takes him into the kitchen and puts him in this fetal position? That didn't happen, ladies and gentlemen of the jury. And how do we know that? He fell in the kitchen because there was one witness, and he hit his head against the counter because there was one witness, and that was the sister of my client, who told you that she saw a dent, a fresh dent in the counter, in the kitchen counter. That's where he hit his head.
But no
that's how he fell
injuries
on the
to the
ground,
head. Don't go into that
on
one.
the kitchen floor. But not because some insulin injection, but because of some unknown condition that was caused or may have been caused by many, many, many different reasons. Then, continuing with the cold-blooded killer's action, she does not.
Did they change theories? If so, that's automatic reasonable doubt. You can't go the entire trial saying it happened one way and then change it in closing to say it happened, say other ways. Well, it'll still have to rely on the jury to pick up on it, but I don't think they really changed the theories during the closing, but during the trial, they have been all over the place with the what if, why.
Anything but call all kinds of people to the house. Now, wait a minute. You have just decided to kill your husband. He is unconscious, let's assume, and you want him dead. Well, let him die then. Don't do anything. Or maybe put a pillow over his head and kill him. But do not tell me that you want to kill your husband and then you call 2 workers right there to bring Michael onto the couch. The sister and her husband, the state trooper and his wife, who is a medical assistant, and then Mr. Davis. Is that the action of a killer who wants to get away with murder? No. And then, and again, I told you, that's the kicker. Then he dies, and she wants to hide all the evidence. She cremates him. And then all the evidence is gone. All these Dr. Kubitscheks and everybody else can look at all that evidence. No, they can't because he's cremated. That's how you, I guess, kill somebody the way the state believed it happened. But it didn't happen that way. And then the ultimate question, and the question is why?
Yeah, poison is the weapon of women.
Throughout this case, the leitmotif, the state's main motif in this case was Michael didn't know anything about this business. Didn't know anything about Natalie's shenanigans, financial, the fraud, the deception, the lies. He didn't know anything about it. Well, I think that from the very first day, ladies and gentlemen of the jury, you've realized that this is not the case. But let's assume for a moment that Michael is indeed blind and doesn't know anything about millions of dollars, hundreds and thousands of dollars. He doesn't realize where all that sudden wealth came from, doesn't know anything. And then he finally finds out. Let's assume that he finds out. And then the state tells you that he would do what? Well, the state cannot tell you. And the question is, what would he do? What would he do that would be so bad that would require Natalie Cochran to kill him? I mean, scenarios abound. You find out that your spouse is cheating the government, cheating the investors. What do you want to do? Well, you probably want to say, come on, let's get a lawyer. Let's get an accountant. Let's try to work it out. Let's call these investors. Let's try to pay the money back. Let's file for a bankruptcy. Let's maybe even talk to a friendly prosecutor in Raleigh County. Maybe you will have to do a little bit of time, but not run to the federal government and complain. What, was he gonna kill her? Is there any evidence that she launched this preemptive strike against him because he was gonna kill her, or that he was gonna do something to her, divorce her? What? What would be her motive to kill him? Why? She may have been afraid that he would be mad, but to kill him, to eliminate him from what? From doing what? From going to the federal government? From complaining that my image is so tarnished now in the community that I want to divorce you and you will be penniless and all of that? There's no evidence of that, ladies and gentlemen of the jury. What triggered this murder? The state cannot answer that question. But if you had any doubts about Michael being involved in this scheme, and if you believe that he was, then the state's entire case collapses. Because she, Natalie Cochran, would have no reason to kill him. Because he, Michael Cochran, was as involved in this conspiracy as she was. And how do we know it? Well, he was working on these contracts daily, on these federal contracts daily. Even when he was hunting with his little son, he had a contract that he was working on. He was working on the contracts when they were in bed. And I'm not talking about anything sexual here. I'm talking about family. She's watching the TV. He is working on the contracts. Their little son with them, sitting between them, realizing that daddy's working on the federal contracts.
Yeah, that sounds stupid.
He signs the checks from the company. He has access to everything, every bit of information that goes through this company, checks, contracts. He has access to all of that. And besides, is he really living on a different planet from Natalie? Ladies and gentlemen of the jury,
It's always on my bingo card.
if I suspected my wife, we are, well, unless I'm in court, we're home. We're together. We spend time together. We communicate. Wouldn't I ask my wife, honey, where is all this money coming from? All of a sudden, I'm not working. I'm this computer tech guy. You're not working. All of a sudden, we're buying 2 boats. Well, the investors, yeah, but now we have 3 houses. Now, we just got back from Paris. Ladies and gentlemen of the jury, you've heard the evidence of incredible wealth, incredible injection, maybe that's a bad word, injection of wealth that Mr. and Mrs. Cochran had in
Funny, I said Smacks is always on my bingo card, and Little D shows up.
2018, 2019, maybe even 2017. And that came from the investors. And the investors dealt with Michael individually, just like his parents. They gave him some $44,000. He knew that there were no contracts. What contracts were they? What contracts were there? He didn't have a clue about some of the business, I'm sure. But he had deep, profound knowledge of how much people invested, who was gonna get paid for what, federal contracts. He had deep, profound knowledge of it. I'm sure there were some aspects of this business that he may not even know about. And I'm sure that Natalie was involved in this. But she is not here on trial for fraud. She's here on trial for murder. Well, let's look at the state's case. And mind you, the state has a very heavy burden, and the burden of proof beyond a reasonable doubt. Well, the state brought the evidence of the pilot who says, well, the flight was canceled. Okay. The banker turned mind reader. He had an idea why the flight was canceled. Of course, he didn't. He is mad at Natalie because he had to do all that research for the company and didn't get paid for it, I'm sure. And for him, time is money. So they didn't fly to Lynchburg. Well,
All the words just put up are the ones mentioned.
Natalie went to a doctor. She was sick. I think that the state attributes all these nefarious things to her, but isn't it just plain obvious from Dr. Halsey's testimony that she was sick? She was sick on Friday and she was sick on Saturday. And what did he give her? He gave her a steroid shot that increases blood sugar. So she's calling her friend, Miss Davis, to get her some insulin to maybe level off the sugar, blood sugar. What's so unusual about it? No, it's nothing unusual about it because she, Natalie Cochran, had a long-standing relationship with the Davises, who had a misfortune, tragic misfortune of having a child who was diabetic. And Mrs. Davis came here and told you, no, Natalie never had any insulin. Oh, really? But then when we confronted her with the pharmacy records, she said, oh yeah, Natalie could pick up the insulin, but she was bringing it home. Well, what if you weren't home? Yeah, she doesn't explain it. Natalie could keep it at home. That was nothing unusual about Natalie having insulin. And you know what? The state wants you to believe that this insulin, that bottle of insulin that was found, was the weapon, the murder weapon. That somehow it was punctured and she kept that bottle as some kind of sick souvenir of the murder. Is that what the state telling you? I submit to you, ladies and gentlemen of the jury, if you look all you need to look at is this humolog that we introduced in the exhibit as an exhibit. I'll submit to you that a blind fool would tell you that this bottle is full. This bottle is full. There is nothing in this bottle that has been taken. There's no bubble, no nothing. The bottle is full. I suspect I know what happened, why there's a puncture. All these FBI gentlemen got that bottle and maybe had taken a little sample of what to determine what it is. That may be the puncture. But otherwise, the bottle is full. We're not going to sit here and speculate. They find a vial of insulin that is full 4 months after the demise of Michael Cochran. And then, that's part of their evidence. Remember Mr. Bledsoe telling you at the end when we finally pressed him, is there any evidence? Is there any evidence that the bottle that you have was the murder weapon? And the answer was no. And ladies and gentlemen of the jury, the lifelong condemnation of this woman versus complete exoneration is at stake. The stigma of conviction for murder versus letting her go free is teetering in the balance, and the state has the audacity to come here with an item that is not the evidence, and they're trying to tell you to convict this woman of murder based on something that is not the evidence. Is that the case that the state has the audacity to bring before you? Well, let's look further. Chris Davis and at least one other witness, Mr. Treadway, and Penny Lowry, knew that Michael Cochran was taking all those steroids. Whatever, steroids maybe. Maybe they were steroids. Maybe they were not steroids. Maybe they were anabolics. We don't know. Michael was taking substances by the fistfuls. And they can say that, oh, we have isolated one little vial, and that was some hormonal thing from Mexico. No, ladies and gentlemen of the jury. He had a cabinet full of medications. He had a cabinet full of that away from the family, away from the cabinet for our place where the family stored the medication. He was getting this stuff online. He had the United States Postal Service box where he would get all that stuff. And I submit to you that this was not some one deal Mexico thing. And there's nothing wrong about Mexico. This was, however, the problem. He was getting substances that were not approved by the American government, by the, the Food and Drug Administration. He was getting substances that were going to increase his physique, his appearance. But my God, they could have done some serious damage and probably did some serious damage. One of them was not even for human consumption, as the children told you. There was just a sample of what Michael Cochran was taking. And what he was not taking was the medication that was prescribed to him by the physicians. And yes, he had all kinds of conditions for which he had the medications. He had Keppra, he had all kinds of serious medications which he didn't take.
Why didn't you
Because he
get your
believed that
doctors
all
to
the doctors were
testify to that?
quacks. He believed that they were not the
Physique has
people
been said.
to be trusted. Chris Davis and Mr. Treadway and Penny Lowry tell him, you have to stop this stuff. You really cannot do this. And what does he tell Penny Lowry? She testifies. He said, "Oh, retarded Penny. What do you know? I'm gonna do whatever I want to."
I would love to make a short of that, but I'm pretty sure I can't make a short of what he just said.
The state makes a big deal out of, well, Michael not being taken to the hospital. But you have witness after witness who told you that Michael not only believed that the doctors were quacks, but he hated going to the hospital. He vowed to kill somebody if he's ever awakened in a hospital. And why?
Could kill
Because
someone
he thinks
for
it's a waste of
just
time.
talking.
Now, he had all kinds of problems that he went to the hospital with. And within the last 3 months of his life, he went to the hospital 3 times. October 31st. And then he stayed there for a day. I told him he had all kinds of problems. Then he went back to the hospital with pretty much the same conditions that he had now and stayed there for 5 days. And then he came out. You heard throughout this trial that Michael had convulsions, seizure-like activity. He probably had epilepsy. The doctors told you that. He had a brain mass that was later modified into the brain swelling, encephalopathy. Ladies and gentlemen of the jury, those are serious conditions. They are not to be laughed at. Those are very serious conditions. He retained urine. He had an enlarged heart. He had an acute respiratory failure. He couldn't even breathe because he had a chronic sinusitis.
We have a possible bingo. Go, go, go. Taz, please put in the 3 numbers on top of your bingo, bingo, bingo card so we can test control. Bingo card 004. Or as they say in Mexico, 004. No, 40. I learned to speak Spanish from Iris. She said, just put an O on the end. It'll work. So now I have to prattle on while we're testing. Did she get bingo, bingo, bingo? We have an accusation of cheating. Brandon claims Tash didn't have that card. It was Brandon's. We will have to do that later. We will have an inquiry. We will put down a special subcommittee that will look at, did someone steal Brandon's card? Because Brandon has been cheated a lot this year. He's been cheated out of every membership chat, every possible win he could have in the best of. Well, that's not true. He won best in chat. But will he be cheated out of his first bingo win? Time for a Panera bread for the jury. Yeah. Let's get to Panama bread and have some queso. See you later, Money G. That's cheating everywhere, especially in court. But these people, we have a winner. Inner. Tash is now the Binkster of the Cochran trial. The Cockster. If you want, Jemima has said that she will send some stickers that is channel specific. Should she contact you directly, contact me directly, contact how directly? Pronounced Tosh? No, it's with an A, it's Tash. I can read. I can't speak, but I can read. Well, I am dyslexic. Was it an X or was it a full card? Well, we'll see. It was on an X.
Nobody is here.
Tash, on this channel, I get to name people. They believe they have a name. Jemima thinks her name is Jess. Iris thinks her name is Iris. I might.
To desecrate or dishonor his life. He
Thank you,
died
Gina Klosterman.
much too premature.
That means cloister man.
Early. He died at the age of 38 years. Not for a moment should you think that the defense is taking his death lightly. No. It's a horrible tragedy. Horrible tragedy. But a tragedy, not a murder. It's a tragedy, ladies and gentlemen of the jury. But with all these conditions, Michael was still doing what Michael was doing, taking supplements, anabolics, substances that God only knows where they came from and who approved them. And he was a ticking bomb.
Oh,
How do we know that? Well, after
there's some broken baker stickers on the spring store. Maybe I'll have a talk with Jess. Maybe we can do it cheaper through her if she want to do it. I don't know, but we'll have to talk to her about it. Okay, we can still play for full card as well. We are doing blackout, blackout, blackout.
his second,
Because he has been practicing his entire life in the US. He I think he came over in 80 something.
stay in a hospital, at least 3 witnesses told us that Michael's health
I need a Bible.
deteriorated
Come on.
to the point where Michael was not the same guy. When he was Michael at his best, he was generous, gregarious, going to parties, participating in tough man competitions, lived life to the fullest. He was focused. After his second stay in a hospital, Michael could not find his car in a parking lot. Forget that. That happens to me quite frequently. But that's not what, that was just one symptom. He could not fix a light fixture with Mr. Davis. He felt confused. The children testified he had constant headaches. He was irritable. He didn't know where he was. Treadway, Mr. Treadway, came here and testified, Michael hated going to Panera Bread with a passion. He hated the restaurant completely. And I know that this is not a case about Panera Bread. But if I hate a restaurant, I'm not going to set foot there. And yet Michael went there and could not even recognize the fact that Mr. Treadway was wearing the same hat that he's been wearing for years. He was confused. There was something going on in his head that made him go where he would never go, and that made him forget who his friend was, really. Now, the state brought before you those 2 FBI agents who, again, could not contribute anything scientific except for that bottle. And the state closed the case with 2 law enforcement officers who are here today. Have you ever seen a more shoddy investigation that took place in this case? They never talked to the children. And I know that the state will say, oh, this was not that important. It was important. The children's testimony was riveting in this case, and I'll come back to that in a second. They did not even check what kind of medication this man was using. And for that matter, they have no clue about Natalie Cochran's medication. And, you know, they tried to convict her in part because she lied about her cancer. Oh, that's a low blow. First of all, We have absolutely no evidence that she did not have cancer. We have the evidence that she was going to seek help from the Cleveland Clinic, from Duke, from the doctors, wherever she could. And knowing our medical system in this country, it's not that you're going to walk into the Cleveland Clinic and you get treatment the same day. You have to have insurance. You have to have all kinds of, you have to go through all kinds of hoops to be seen by a specialist. And maybe when she told somebody, yeah, I have cancer, leave me alone, because she maybe didn't want to discuss her health with somebody, maybe in reality she was checking out whether she had cancer and went to all kinds of doctors and clinics to obtain that health. And the state believes, oh, she lied because she told you that she had cancer. The officers ignored the federal investigation completely. And in the federal investigation, in the indictment, in the forfeiture proceedings, in the federal case, it's the Cochrans who were responsible for the Ponzi scheme. But the indictment didn't come until September of 2019, and Michael was dead. I submit to you that the federal government was investigating them both. They can come here and say, well, I saw some cases where the couples were not investigated together. That's baloney. The federal government investigated them both and would have indicted Michael as quickly as they indicted Natalie for the same offenses, because Michael was involved in this Ponzi scheme up to his eyeballs.
Because she wasn't diagnosed till after.
Now, let's see what evidence the defendant presented. Remember Nurse Hawley, if I pronounce it correctly, Hawley, yes, who said that she was at hospice. And what did she observe? Natalie Cochran was with her husband for the last 5 days and held his hand when he passed away.
She was found to have some kind of, I think it was some kind of bone marrow thing, a weird diagnosis. They talked about it. And she also had some heart trouble with the electrical signals in her heart. But it wasn't diagnosed till later.
There's evidence that Natalie Cochran got into a car with Mr. Davis. Well, the state said, oh no, she didn't drive him to the hospital. Well, she didn't drive him, but she was a passenger in that vehicle driven by Mr. Davis. She didn't drive him because she was too distraught over his condition, but she still got into the car and held his hand. Is that the cold-blooded killer? She also testified that Natalie Cochran was a go-to woman, and I think that she may have used that phrase, or maybe I have used that phrase, when it came to the emergency situations involving Mr. and Mrs. Davis's child. So Natalie Cochran would have to have insulin. You don't treat insulin with a water pill, for God's sake. You have to have insulin to treat it. And if she was a go-to woman, she must have had insulin to treat the Davis's child. So there should be no surprise again that she had insulin in her possession. Mr. Treadway didn't want to talk to the police because he believed they were dishonest crooks. And he somehow, by the way, he got scammed financially. So he had absolutely no reason to be friendly to Natalie Cochran and testify on her behalf. Similarly to all these other witnesses, even her sister got scammed to the tune of about 50 grand. And yet she came and testified for her sister. What did Treadway tell you? Well, Michael was confused. Michael wasn't the same guy that he had been before. And then Penny Lowry. the retarded Penny, as Michael called her. She told you not only about that fresh dent in the kitchen counter, but Michael wanted to pay her back what she owed on the contract. Michael wanted to pay her back. Michael was dealing and wheeling with the money from the investors. He knew about it. She told you, again, the same story, that Michael refused to go to the hospital because he was going to kill somebody if he went back to the hospital and woke up there. And we have all these discussions between 5 or 6 people after Michael collapsed in the kitchen. And then I told you that the children testified in a riveting way. And you're gonna tell us, well, the state probably will tell you they're coached, or they were somehow not truthful. Two tragic figures, two children who were young enough to be taken care of by father and mother, and old enough to know what was going on around their house. Nikki testified here unequivocally that her father had headaches, he was confused, had a brain fog, was agitated. In a true, genuine, heartfelt way, she told you that he may not have been as loving towards her as he was towards their son. Michael had a heart-to-heart with her shortly before he died, and her impression was that her father felt it coming. And what was it? It was death, ladies and gentlemen of the jury. Michael felt it coming, and he had this heart-to-heart conversation with her, which she considered heartrending, and which we would consider his farewell to life, because he knew that there was something irreversibly wrong with him. The MAC, their son, testified too. Dad worked on the contracts all the time, even when hunting, even in bed. And he testified about their lifestyle. He testified about the supplements, the injections, the dropper, the stuff from Mexico, as he called it. Stuff that wasn't for human consumption. He remembered it all. He testified about his father's anger, his father's combativeness, his father's confusion. Now, I want to talk to you very briefly about, before I do that, there was also a brief mention of nootropics, a medicine that came from some shady, well, maybe not shady, I shouldn't say that, places that usually would not be available in your local friendly pharmacy. That was the smart drugs that Michael was receiving at his USPS, United States Postal Service box. These were the cognitive enhancers, memory enhancers, stimulants. Michael was perhaps a man's man, and he would not admit to any weakness. He was seeking desperately to look great, to be this, I don't know, alpha male, whatever you call it, to be this great, maybe bodybuilder, maybe an athlete. And yet, in all of this, he didn't follow the advice of those who should have given him the advice and who he should have listened to, and instead did his on his own. Now, I want to return for a second to the experts who testified in this case. let's start with Dr. Kubitschek. All of these experts, by the way, had a number of autopsies that performed. But who was in the best position to tell you about the autopsies? Who was in the best position? Well, of course, it was Dr. Kubitschek. He performed the autopsy the earliest. And with all the help of the state resources, and relatively early in the game, when the body was not perhaps yet decomposed to the point that nobody could recognize the organs anymore, he told you that the cause and manner of death was undetermined. Then there was Dr. Howley, who was not necessarily an expert, but he told you a couple of nice things. One is about Natalie being sick, but he also said something about tablets, the pills, and the state jumped on it. And now the state submitted another theory that maybe Michael was killed by Natalie with pills. For that matter, the state is bringing another theory now that maybe she killed him with the benzos. You heard about the benzos. Now the state says maybe there were 2 shots of insulin or maybe more. Now the state tells you she killed him in the kitchen. Now she killed him in the bedroom. Now she killed him with the prednisone, maybe. And then maybe any other substance. And the state will stand up at the end and tell you that whatever I tell you is a bunch of nonsense. But, ladies and gentlemen, you've listened to the evidence. If the state stuck to its theory that there was 1 insulin shot, I could buy it. But now the state quietly is telling you, well, we're not telling you that the evidence suggests that the defendant killed her husband with insulin. There may have been pills, there may have been benzos. They're intimating this because they don't have any direct evidence, to which they immediately admitted, but they don't have any circumstantial evidence that fits either. Now, you had Dr. Dragovich, who told you maybe one very important thing, and that is that the decomposition of the body caused the inability of any doctor, for that matter, to assess objective factors, objective anatomical factors, and the findings of any type of specific, concrete reasons for Michael's death. That is impossible. Dr. Uribe believed that there was an insulin shot, but this was just an assumption. It was kind of a bridge to the unknown, and I think that was his phrase. It was just an opinion. Dr. Krieger said, well, we've excluded maybe all the other options, but it's a definite maybe, as we call it. It's a definite maybe. Maybe there was an insulin shot, but we don't really have all that information upon which we can construe our theory.
Hey, Gabby.
And then Dr. Banerjee came here, and she said, we don't know. She's our expert. Maybe you expected her to say, oh yeah, that was an insulin shot that was responsible. That was some other reason. She didn't say that. She testified like 4 other experts that we really don't know. But there are other possibilities. There was something wrong with Michael's pancreas. Remember that? He may have had pancreatic tumor. He obviously had an enlarged heart, arrhythmia. Maybe there was something wrong. Maybe that was the reason. The tests were not done on NAC peptide insulin. No meaningful diagnosis from the sliders that were obtained. or that weren't obtained,
He's just
could
going
have
on too
OD'd
long.
on benzos. We don't know. Benzo overdose, maybe poisoning. Hypoglycemia equals death. Well,
He's
all
getting
of
close
that.
to an hour.
And then, of course, there are other reasons. The medication, alcohol, unexplained medications, liver disease, sepsis, surgeries, immune system. All of this could be taken into account in Michael's death. But the state stubbornly believes that Michael's death was caused by that one insulin shot, which they, by the way, changed and modified to maybe 2 or 3 on all these versions. It's impossible. Impossible, ladies and gentlemen of the jury. Now, the state also brings a theory of maybe there's this voluntary manslaughter, that just because she didn't take him to the hospital. Now, I submit to you.
Yes, you've been bullied for being a Swede. Deservedly so. I'm just going to end the poll because he's about to end this one. The poll on did state closing convince you of guilt? 25% says yes, 74% says no.
That not taking Michael to the hospital was not done over the period of days. It was a matter of hours. It was a matter of discussing Michael's preferences and will, whether he was going to go to the hospital, whether he wanted to go to the hospital, and what was necessary. We had several people in that house who could have decided. Finally, it was decided that Michael was going to the hospital because he was not waking up. Yes, it took some time, but there was always the hope that he would wake up in his own home, surrounded by family and friends, and everything would be fine. After several hours, yes, it became necessary to take him to the hospital. But that's all. Now, ladies and gentlemen,
Do we think they're gonna be sent home after this?
You at the very beginning of this case that this is a complex case. That this is a case that involves medical, banking, scientific,
He's almost done.
maybe pharmaceutical, maybe business evidence and information. There are aspects of federal litigation here. And you've heard it all. But distilled to its essence, this case really involves the state's attempt to equate the federal prosecution and conviction for dishonesty and fraud with murder. The state says she is a fraud, therefore she is a murderer. She is a cold-blooded murderer because she is a cheat. That's what the state is telling you. But the state cannot prove, certainly not beyond any reasonable doubt, the what caused Michael's death, the how did that happen, and why it happened. And so at the end of this case, I will tell you that the state's attempt to equate the fraud with murder is like trying to squeeze a square peg into a round hole. And if that one peg didn't fit, then the state switched the theory, and let's see if another peg that is still square will fit into that hole. Oh, no, it won't. Well, then we'll switch to another theory. Maybe benzos, maybe two shots of insulin, and it still doesn't fit. Ladies and gentlemen of the jury, the state will have the last word. In the criminal process, I will sit down and I will not address you again. My esteemed colleagues and friends will get up and tell you that whatever I told you is nonsense. They will give you the spin on the facts and tell you that's the way it is. But I heard a statement once that, and of course, when you go to the jury room, since they spoke last, you will have their words in your mind, in your memory more than my words. But I heard a statement once that it's not the one who speaks last, or trust, not the one who speaks last, but who speaks the truth. We have no reason to come here and hide anything from you, ladies and gentlemen of the jury. Ms. Cochran should not be perhaps invited home for you to have dinner with her on Sunday. I told you that. She is committed crimes of fraud, crimes of mail fraud, crimes of dishonesty, but that doesn't make her a murderer. And if you cannot answer these three questions, what, how, and first of all and foremost, why, then the state fails to prove its case beyond a reasonable doubt. And that's why we're asking you to find her not guilty.
I know nothing. He should have kept it at the 30 minutes he's talked about to begin with. He went way too long. He started okay, in my opinion, put a lot of holes in it, and then he just kept rambling because I must fill an hour. He shouldn't have done that. He should have done it way less. He did the right thing, said none of this is evidence of anything. I think 20 minutes would have been perfect. The jury would have sat there and thought, oh my God, why did the other lady ramble on for so long? Now he did what sometimes happens to me when I do my night show, when I get to like half an hour mark, I'm thinking, what the F am I going to talk about? I'll start talking about Titanic. And then I'll get my wind back and start to be less coherent again. Way too long. He started rambling in the end. You don't need to use your allotted time. Most of the times you shouldn't. That's my thing. The problem is they if he had just used the first 20 minutes and sat down, they would have remembered everything. Now they remember nothing. Oh, by the way, did you all know she injected him in the hospital twice? When I took my bio break, I turned the stream on and I could see Law and Crimes chat. She injected him twice in the hospital. It's proven now. Let's get back
Reply, Ms.
to...
Akron.
No, get back to me. You were so close to listening to all the stuff. Be silent on this side, and then you will take over. On behalf of the prosecutors, excuse me, on behalf of the prosecuting attorney's office, the investigators, we thank you for your time, your effort, your attention.
Your colleague already did that. Shut up. Get to the point. We are bored.
Your sacrifice. Without you, this system cannot work. Can I touch your equipment? I should have asked.
Let's make sure. Can I touch your equipment?
Sure. I can make duck shadows on the wall while we get this going. Pointless maker. Okay. Yeah, I'll talk about something else. I'd like to talk with you about two numbers. And the first one is this one. 0. The defense is right. We're going to tell you that what you just heard is a lot of nonsense. And the reason why it's nonsense is the defense has no credible evidence to back up any of their theories as to why the state is wrong. Let's start out with Michael Cochran himself. They have a very schizophrenic approach to Michael Cochran. One theory of the defense is he was this macho bodybuilding, fit guy, athlete, Jeep pulling, super stud guy. That's one theory. Now they have some evidence that he was very concerned about his fitness, very concerned about his appearance. We would agree with that. But did that lead to his death? Zero evidence to support that. On the other side, oh my gosh, the guy was a ticking time bomb. The defense words, a ticking time bomb. He was so sickly. He was essentially a guy with 1 foot in the grave and 1 foot on a banana peel. They don't really have any evidence of that either. He was just a normal 38-year-old healthy male and a good guy by all accounts. So the hospitalizations that they've relied upon to tell you how sickly this man was, where did most of the information come from that? Medical records. Who provided histories for that? The defendant. The defendant told the doctors all of these things about Michael Cochran.
Nope.
It didn't come from other reliable sources. It came from a very unreliable source.
11 years.
So his suspected brain mass, his suspected convulsions, his suspected all of these problems, there was no diagnosis of any of those things. They were suspected. And they were suspected because she told them to suspect that stuff. But there was never a diagnosis. Even their own experts confirmed that. There are other witnesses. The fact that the Davises talked to a nurse to have Natalie Cochran, their emergency contact, that's not the same thing as authorizing treatment by Natalie Cochran of any child. There's zero evidence of that. There is evidence on the other side. The Davises told you they never gave the defendant insulin for the benefit of their child. Never. Both Davises told you that. As recently as yesterday, the defense was still putting that theory out there for you to consider. There's no evidence to support that. Zero. Mr. Treadway's testimony was Mr. Treadway's testimony. This is a guy that didn't want to help the police. Even though his best friend was dead, he wouldn't talk.
BS, then if you're going down that route, tell them that your investigators was part of a plea deal lawsuit where someone beat up a criminal.
And he had some newspaper article he said gave him justification for that. That's on him. Treadway's got to live with that. But he didn't bring anything of substance to this case, did he? No.
He did. He contracted with Michael, only Michael, and Michael told him it had to go through him.
The two children.
This is why I hate the state gets to go last, because now he's just blatantly lying about evidence.
To testify. They are tragic figures. They have had a terrible 6 years. They lost their dad. For the time being, they've lost their mom. But they were little kids. And their testimony had a certain ring to it. They both picked up on the same word, agitated. That's an unusual word. Rolling back time 6 years, think that the oldest was 20. She was 14 at the time. And that's how she's going to describe her dad the last few weeks of his life, the word agitated. Her brother, the same word, and he was younger than her. There's something odd about that. The state believes that they sincerely believe their recollection. But does it make sense? Would kids that age really be that involved in their parents' business? Would they? Well, it's possible, but that's not very likely. The defense experts, nice people, very sincere, but they're in a little silo. If those forensic pathologists can't cut on a dead body and come up with a smoking gun reason, then their opinion was they won't give you a cause of death or a manner of death. Even though Dr. Banerjee said, oh no, we don't do this in darkness. We look at all the facts, we look at all the circumstances, and the autopsy is just a part of the process of determining these things. But was it? Did she have any facts that were right at all? She had a few, but not many. And in her own report, she said, if other information is brought to my attention, I reserve the right to change my opinion. Well, she had a bunch of other information, but she still wouldn't change her opinion. Why not? That's just her mindset. Did she have any experience in insulin cases? This was her first case, her first one. Dr. Brekovich, apparently he didn't have any insulin experience either. Now, the defense told you that the state has just gone all over the lot with its theories. Is that your recollection of the evidence? Did you hear any state witnesses say there was one injection of insulin? No. Did you say multiple? Because we don't know. But there are some things that we do know. Let's talk a little bit about how that balances out what the defense just told you. There's a lot of circumstances that need your consideration. First of all, this is a trained pharmacist, a pharmacist who knows about all sorts of medication, the impact of the medication, the dosage of medication. Beyond that, this defendant held herself out as a diabetes specialist. A diabetes specialist. That's another circumstantial piece of evidence to keep in your mind. On February 6th of 2019, on the basis of a supposed counterbalance to her cancer treatment, she needs to borrow a bottle of insulin. Another circumstance that needs to be held in the back of your mind. Because on that day, they were supposed to fly to the Bank of America. And yes, there is a merger with the federal case and this case, and that's where the merger takes place. You heard Trooper Heinzman discuss all of the things that the defendant had told her investors about the money that was supposed to be coming in, the money that was going to be coming in, the money that was almost going to come in, and it never did. Who else did she tell that to? Michael Cochran. So when the defense says, oh, he was up to his eyeballs in this, was he? Does the evidence support that? They have zero evidence to support that.
Just as much as you have, he wasn't
did with
in
a lavish
there.
lifestyle. But if he thought that the money was there for good cause and that the business was just supporting that lifestyle, was there anything wrong with that? Of course not. But this was a person who ran a Ponzi scheme. And the one thing you can count on for people that run Ponzi schemes is they will do whatever they can to keep it going. Is that what she did? That's exactly what she did. She was still shucking and jiving after Michael Cochran died, right up until the...
How many Ponzi schemes have had people unalive their partner to keep it going? Again, I hate they get to lie.
executed the search warrant, she was doing ordinary business, selling the non-existent contracts, trying to get people to invest. So there is zero evidence that Michael Cochran was up to his eyeballs in this, but this defendant was up to her eyeballs and over her head in this fraud scheme.
No proof of it. It's just something they
Second
brought up.
21. That's a big number. And that's the number we're going to rely on to convince you beyond a reasonable doubt that this defendant killed Michael Cochran. That number was the number of his blood glucose level at Raleigh General Hospital
Blood glucose.
the day of his collapse. Now, unlike the defense witnesses, the state witnesses were unified and very clear as to what caused that 21 number. Dr. Krieger had 13 likely causes of low blood sugar, hypoglycemia. She eliminated all but insulin. And she's got a good reason for all of them. You heard her testimony. All of those were potentially valid causes of the condition that led to the brain swelling, that led to the death of Michael Cochran, all of them. But she eliminated by logic and by her scientific skills and experience in insulin cases that it had to come from insulin. Dr. Uribe, another experienced insulin investigator. Both of those two were involved in the Clarksburg VA murder cases where a nurse was killing veterans with insulin. Those two were the government's star witnesses. They know what they're talking about when it comes to insulin. And it comes to insulin killing people. That's what they do. So that 21 was never overcome by a single shred of credible evidence by the defense. Not once. No one's told you from the state that there were single injections, multiple injections. We don't know the answer to that. We do know that Michael Cochran's death was caused by insulin and reducing his blood sugar to a fatal level, and the resulting changes in his brain killed that man. Circumstantial evidence is the basis of this case, and let's get this a nice, straightforward example of what that is. It's January in Raleigh County. You look outside your window and you see frost on your neighbor's truck, frost on the ground. Stars are out, moon may be out. You go to bed. You wake up the next morning and there's 8 inches of snow on top of the truck and on top of your grass. Did you see it snow? No. Did it snow? You absolutely know it did. That's circumstantial evidence. Ladies and gentlemen, the state of West Virginia has dumped a blizzard of circumstantial evidence on this defendant. Until today, 2 weeks in an American courtroom. And until today, you never heard the word justice. Well, do justice for Michael Cochran. Find this defendant guilty of first-degree murder, because that's exactly what she did. Thank you.
Members of the jury, you have now reached the final stage of the trial. This is the point where I would ordinarily release the alternate jurors and send the regular jurors to the jury room to deliberate upon your verdict. I see that the time is almost 15 till 5. Ordinarily, I would close out the day at this time, as you know, and send you home for a nice dinner and watching TV and then going to bed. However, you folks are in the catbird seats. You are the judges of the facts, and you can tell me at this juncture what you want to do. And if you would like to retire now to deliberate upon the verdict, that would be fine. We will stay here and we will wait until you reach a verdict. However, if you would like to start afresh tomorrow, deep in the heart of a good night's sleep, you can think a little more clearly, you can come back at 9 o'clock at the regular time and commence your deliberations then. We have talked among the attorneys about engaging in a powwow among themselves, and I would urge you to engage in a powwow among yourselves and see if you can reach some unanimity on what to do. Again, you can stay this evening and deliberate, or you can come back tomorrow. Perhaps you can confer for a moment or so and decide what you all would like to do. I'm hearing tomorrow. All right. That's the decision I would make. But again, I'm not you guys. I'm not going to release the 2 alternate jurors. I'll ask you folks to come back with us, because I've been at this game a long time, and I know that anything can happen with jurors in terms of sickness and accidents and that sort of thing. We've done really well, and you folks have been great. You've been here promptly. You have watched and considered everything. I've been sneaking looks at you, and I noticed that you have done very well in terms of paying attention to the evidence and the proceedings. So I will ask all of you to come
Don't
back
throw out
tomorrow.
your bingo
Even though
cards.
we have
We
reached
will
the
find another
deliberation
winner.
phase, you still can't talk about the case because you haven't started your deliberations. And I'll tell you in the morning that you all need to be together. You all need to discuss the case together and not break up out into factions or have folks wander off. You need to talk about this together and share your concerns and share the issues that you have arrived at. So that will be to start tomorrow. I'll tell you about selecting a jury foreperson in the morning, and we will get down to business. So if you could all be back in your jury room at a little bit before 9. Do not discuss the case among yourselves. You're not at the deliberation phase yet. Do not talk about it to anyone else. Don't watch TV about it. Don't do any research online or see anything online. And please don't read anything in the newspaper about this case. Have a good evening, and I'll see you folks at 9 o'clock in the morning. You may follow the bailiff.
They haven't come back. That's the wrong one. This one. Now, everything is in the hands of the jurors. They will come back tomorrow, 9 o'clock, go on verdict watch. We still have blackout bingo left. So Jemima will pick one word of those left. Then she'll give it a little time. We'll pick another word. And we'll go till someone else wins the last stickers or whatever she was thinking about sending. And thank you so much, Jemima, for doing that. Especially in a hearing like this, that's so... I really dislike the way he was doing it, Mr. Poland. He should have kept it at 20 minutes, I believe. 20 minutes, maybe half an hour. He was doing great until then. The problem was when I think it's maybe it's just a human thing. Good night, Skybell. Maybe it's a human thing where I must use time allotted to me. But most of the time, the longer you speak, the less you say, if I can say it in that way, because he totally lost me. Totally lost me in the end. He just kept reiterating stuff, and I just don't feel that it was that good what he was doing. I'm sorry. I'm just looking to see if that other trial we were looking at, if there's anything about that, because if nothing else, we'll try and see if that stipulation out of Florida goes live tomorrow. We can cover that while we're waiting for this one. See you later, FD Food Fairy. So, yeah, he was all over the place. Should we get the words rolling? Jess has just updated all the words that has been said so far. And we'll pick one by one. We'll pick one, give you a little time to respond, pick another one, and give you a little time to respond. Word number 1 will be mold exposure. And I will look at my clock and give it 30 seconds. 30 seconds before I ask for another word. Pa-ba-bum-bum, ba ba bum bum, ba ba bum ba ba bum 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 bum, ba ba bum bum, ba ba bum bum, bum ba ba bum bum bum. Can we please have another word? But agitated was said, yes. Winner, winner, chicken dinner. Before the second word comes out, Brandon claims winner. Can we have the number on your card, Brandon? The second word has been played, but Brandon claimed bingo before second word came out. So let's see if Brandon this time. And remember, it's just not, you have to fill out the entire card. You didn't say bingo. Second word is chemo. Chemo. You'll get 30 seconds to put that in there. MG Law has bingo. MG Law did say bingo, so is that correct? The number of your bingo card. Card number 69. I think this might be another cheater. Salty Dog, I trust MG. He's a lawyer. A lawyer can't lie. Can I have another word? Because apparently people are funny today. Oh, lawyer, liar. Oh, Word number 3, semi-legal drugs. We have some very, very long words. Well, I don't know. Maybe you had someone do it. Yeah, semi-legal. You know, when it's not completely illegal. Number 4, lavish. Lavish. Like living high on a hog. Lavish. Lavish. Of course you do. Of course you have some semi-legal drugs. Very sexy car. I can't see that if the jury has been seated in the Colin Griffin case. Well, I don't know. You have to take that up with the rule committee. I don't know. I don't know. I don't know anything about this game. I'm just hanging around. Oh, word number 5. Innocente. Innocente. That's Spanish for innocent, Jamie. Innocente. Innocent, innocent, innocent. Just like me. Young, sweet, and innocent. But if you weren't around yesterday, the case that I'm hoping they're going to pick up on YouTube, because if they're playing it on Court TV's website, I won't share it because there's so many commercials. But it's a teenager standing trial for charges of unaliving his mother 18 months after he unalived his father. But he claims he acted in self-defense. So that's kind of Letrosole, I don't know. The medicine. He's charged with kidnapping and first-degree Redrum in the stabulation death of his mother last year. It's a very quick case, September 8th last year. He claims self-defense and told 911 that she fell on the stabulator during a very long fight. And he was in custody of his mother at the time, but had fled to his grandmother's house after they argued over chores. Prosecutor says Catherine went to get her son to bring him home, and within 30 minutes of her arrival, witnesses say they saw Colin dragging her by the hair. Colin was previously arrested on charges of DV in November for an incident with his mother. At that time, the police reporting captured him telling his grandmother and deputies that he did not want to be returned to his mother's custody. I'm in a constant state of fight and flight, Colin told deputies at the time. If I think she's going to do something, even if she's not, I might act. I'm not going to go crazy or anything, but I'm not sure, honestly. No new words. 18 months before his mother's death, Colin was charged with first-degree Redrum after shooting his father in Oklahoma. Prosecutors dropped the charges less than a month later, saying they could not disprove his assertion of self-defense. Prosecutors in Florida have pointed to texts they say show Catherine was threatening to reveal that Colin has not acted in self-defense in that case. While the jury will hear that Colin shot and killed someone in self-defense, the judge ruled that they will not hear the victim's name or learn that it was the father. Word number 7, smoke screen. Not a smoke show like me, but a smoke screen. I'm sorry, Gina. So hopefully it'll be on a channel. We can see it if they start tomorrow. It'll be perfect if it started tomorrow. Tomorrow is Wednesday. Friday we'll be doing, Karen Reed will have an evidentiary hearing, and there'll be a hearing on motions. If Bev is gonna do it, it could be a full day. If she's gonna do her normal thing and say, well, I got it in writing, see you next time. I don't know. The defense have filed a motion on behalf of Green today, claiming that they didn't get the original files for the digital forensic, which could be another Brady violation, as apparently a defense expert had found earlier that the 227 search happened. It's a very long document, a lot of technical stuff, probably something that the Russian bot will understand, but I'll have a look at it. Maybe it's something I can talk about, but the technical stuff, I'm not that great. Word number 8, exhumed. Exhumed. Like I exhumed my channel back up to 12,811, and now I'm back between below 12,700, the 12,800 again. We don't care how many cards you have at this point. We want to finish. Danny T wants to go to bed. So do I. It's 11 o'clock. But boom, 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 boom. Homework assignment. Watch movie Drowning Mona. Never heard about it. Word number 9. This is related to Zachariah. Brain damage. Brain damage. Zach, brain damage. Brain damage. It's damage to the brain. Pinkety brain. What are we doing today, Pinky? No, brain. The same as every day, Pinky. Taking over the world. Planning to take over the world. Who remembers Pinky and the Brain? That was a great show. It's Pinky and the Brain. Pinkety brain. Word number 10, bladder. Ladder. Well, we had one winner. Jemima just wanted to do a cross out. Bladder. I don't know what Caliu is. Caliu. Cielu? I don't know. Don't ask me. That's the wrong question. Who could forget Pinky and the Brain? Correct. Don't you whiz on the electrical fence? That was back when you could have fun with cartoons. Kaiju. Kalu. I remember Cat Baloo. That was a funny Western. Word number 11 is 140. 140 is word 11. It's French. Gelu. Probably then. It's Pinky and the Brain. Pickety brain. Well, someone isn't holding the punches back. I've never seen the show, so I can't tell if it is a little B word or Well, it was highly inappropriate, but very, very funny back then. I've shown some of the less controversial Danish stuff, but we had fun. Gelu means pebble. Oh. Pink in the Brain is great. Word number 12. Turn her in. Not turn her on, which I can't do, but turn her in. In. Have a great night, diversions. More. Hope to see you in the morning whenever we start. Hopefully with a trial we can watch so we don't have to sit here and do nothing for Verdict Watch. Turn her out. Pimping ain't easy. I'll just say that. Biggity brain. Could be so fun if we could watch old episode on that and comment on that instead of but there's so many problems in doing that, sadly. Animal. I know Brandon has been looking for an animal for a long time. He has been looking for animal. Come on, Brandon. Get to it. Do it. I don't know who owns Warner Brothers now. I don't think it's Disney. I don't think so. No. I don't know. Well, Brandon isn't claiming it. Ba-ba-da-bum, bum, bum, ba-dum, ba-dum. Ba-ba-da-bum, bum, bum, ba-dum. Bingo 060. 060 is a bingo. Bingo on 060. Brandon is claiming bingo for the first time in forever. So hopefully this time it's not a dud. You did it. You finally did it. Let's get it confirmed and get the F out of here because it's 11 o'clock. Je suis un peu fatigué. In the first time in forever. Dum, ba-dum, bum, bum. Bum, ba-dum, bum, bum. Bum, 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 bum. Ba-ba-da-ba-da-ba-da-ba-dum. You know it's always rigged on this channel. I'll let my mods win the big prizes and stuff. Let's go, Brandon is the second winner of the night. Number 2 on your program, number 1 in your heart. Monsieur Lesker Brandon, out of the wonderful city of Long Island, New York. Second winner, sticker dinner. And in a totally unrelated, forgot to bring up today's sponsor. But congratulations, Brandon. You can have a free blackout and you can drink the rest of the beer Valhalla shotgun. Also known as the dog sauce. See, he's never giving up his address. No, I know that. But Jemima lives right from where she lives to where Brandon lives. It's that far. They can meet up at a gas station on the turnpike. But everyone, thank you for playing along. Give big thanks to Jemima and her lovely numbers girls for keeping track of all the words, helping us have a little bit fun because trials do get a little bit boring in the end, especially with all the downtime we had, with all the it became a little redonkulous in the end. Enjoy the rest of your night. I won't be doing a morning show, I think. If I wake up, and I might do a surprise morning show, but right now I'm a little too tired. But we never know what's going to happen. I know the garbage collector is going to be here at 6, so he's going to get me out of bed. Fair. I can send it to your wife, and you can say, "Who's that?" Maybe we should do it that way. So you had an excuse saying, "Are you hooking up with a Danish guy?" Maybe that could help you in further discussions at the house. But everyone, go out, have fun, enjoy the rest of your day. Bingo was great. Thank you so much. It really helps out with all the boredom that goes along with all of this. And yeah, we want to see this trial when she unalives him. Verdict watch will start tomorrow, hopefully with another trial, or I have a ton of Lego I can build. If we're just sitting around talking, I can put the StreamYard link up if anyone want to call in. I don't know if yeah. I don't know if she could hand it after the Gosney book collection. Well, let's not stress. You pay a lot more. Yeah, gambling. That's get to bed. Get to bed. 30 p.m. Yeah, you better get to bed. Jamie is already sleeping. But you know the things I'm supposed to say, or Jemima will say, "Why don't you say it?" You all know what to do. Please go to that Court TV. Who's your favorite? If you feel I'm close to your favorite, and put me in there, because not only for me, but I have been trying to reach out to some content creators. Maybe it helps if they can see that I'm not just someone who started a channel yesterday and is now trying to get them on to grift off of their subscribers, but actually sometimes I do semi-passport content that could possibly be fun to do together with them. So I think a lot of people keep a little eye on stuff like that. So please do it if you wanna, because you can dance if you wanna.
What exhibit are you referring to? I'm going to make this 100, Your Honor. All right. 100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
Go
All right, I'm in love. Go back. Please do that again.
I'm Jimmy. How y'all doing?
You know what we do?
Yes.
When did you first meet